17.
17.
Look. To file any affidavit without that. In this case.
We'll hear it then. Have you taken the consent from
Yes.
this? Mr. S.C. Kell, Learned Standing Counsel, GST, submits that an accommodation be granted to him today and the matter be taken up for consideration after 3 weeks. Prayer is not objected to by the Learned Counsel for the petitioner. Registry to list this matter again after 3 weeks on a date to be fixed by. Interim order, if any, to continue till the next date of listing.
May it please your lordship. I beg to mention I have taken consent from other side. For little accommodation for
Wait.
today lordship, some difficulty lordship.
You should have given a circulated. We have come reading, ma'am. What is there? Be here. I have some queries to the respondent. We'll not dispose it of, don't worry. But I have some queries. We'll not keep this matter pending like this. Madam, you need not be here. We'll not dispose of the matter. Don't worry about it. But I want the respondent counsel here. Kindly inform.
My lord, I beg to mention for item number 9. The respondent 3 has put in our notice, my lord. My lord, they want.
The affidavit was filed way back in 23.
Yes, my lord. That was not.
We'll see. Let the matter come up, Mr. Signet.
Number 29.
Huh? Huh.
6. The same issue is pending before Supreme Court. It is taken on.
SCKL report as na same repeat ko idea after 3 weeks. Item number 29. Interim order, if any, to continue till the next date of listing. Yes, Mr.
14. That are become infraction.
That reservation of strong, weaker.
Yes. That one has already awarded.
Mr. M. Khan, Learned Counsel for the petitioner, submits that during the pendency of the present proceeding, the issue involved has since become infructuous. Full stop. Accordingly, he prays that the petition be closed as having become infructuous. Prayer accepted. Registry. Prayer accepted. The petition stands closed as having become infructuous.
May I please, your lordship? My lord, item number 18, my the relief, my lord. Other
Relief in what sense?
card has been released.
How? Matter is still pending.
But interim order was there, my lord.
Interim order was only for registration, not for release of Aadhaar. Get my point. Let the matter be called up. We'll see.
May I please, your lordship? With the consent of the petitioners, I beg to mention item number 32 and 33, my lord.
Why?
In item number 33, yesterday we have filed our affidavit. They are supposed to file your.
They are supposed if they want only they will file. How can you suppose?
In item number 30,
Mr. Kotoki is ready to do the matter.
we're going to file our affidavit.
We are going to
during the
file an
course of
affidavit in my case today. Item number 32.
32.
32, 33. As prayed for by the Learned Counsel for the parties. Registry prayed for an adjournment in the matter with a view to complete their respective pleadings, registry to list those matters again after
10th, my lord. 10th of September.
list this matter after 3 weeks on a date to be fixed by it. 2 weeks.
That's all.
Wait, please, lordship. Lordship, in the case then, item number 53. Lordship, item number filed an affidavit yesterday showing proof of justice service, which was taken on Friday.
Call for it. Why keep it? Why keep it for another day? Call for it. We'll pass the orders today only. Call for it's only justice service acceptance.
Respondents won't be here.
Huh?
Private respondent won't be here, my lord. Respondent number 4.
Need not be. We'll only accept the service, completion of service only. Call for that record affidavit you have filed. You filed an affidavit.
Filed an affidavit yesterday only, my lord.
Call it. It's only with regard to dusty service. Call it, we'll finish it. Why
That
keep
will
it pending?
That will be done, my lord. And my lord, and for arguing the matter, my lord,
We're
document.
not for arguments today. It's for orders only. We're not arguing, taking it up for disposal. You be here, get the affidavit, we'll clear up the. Why keep for another date? Again, the file has to come back. It's only for acceptance of dusty. Upon that much only, you get the affidavit. Lick it here. You give a note. We are not taking it up for consideration. Don't worry about it. You have filed a dusty affidavit.
We have
All for it. That's all. $49 to a yellow what I have. 49 to a $48. Look at it. Look at it. 14 again. Oh, number orders are serially matter. Yes, Mr. Gugul.
So item one, lordship, I have received certain instructions. Otherwise, that regarding imping order, there is. Otherwise, the matter was, although 2018, we are.
This matter is pending from 2018. Your only case is that it was non-functioning. But the period that is there, it's already been culled out by an order of this court.
Is the other.
8/7/2006 to 1/8/2010. And this is power subsidy. You can always verify whether he has paid that amount to APDCL.
Just for clarification, lordship, they give. Otherwise, I have received certain instructions. This lordship nowhere, lordship, not.
Mr. Saraf has already argued the matter.
That.
Only show me that he is not entitled for any other reason other than this.
That part is here not reflected, otherwise a simple instruction. We are dealing with this matter for the second time, lordship. After 2000, the earlier set of councils.
You have admitted here the unit was closed on 27/1/2016. So, in terms of your policy, it is for 5 years only. And show me that this non-functioning, even if after the incident, period of incident is involved, will be a ground for rejection. That much only you show me, I'll dismiss the writ petition. Mr. K. Gugui, learned. You are appearing as CGC,
No, lordship, as
Huh?
additional senior government advocate. Lordship.
additional senior government advocate, appearing for the state respondent. Submit that he be granted time till 8/9. 8/9/2025 to complete his instructions in the matter. Also, no further adjournment would be granted to either of the parties in the matter. Registry to list this matter again on 8/9/2025 for further hearing.
Oblige, lordship.
You take it back. Yes, Mr. Bhuya, what is the update?
Regarding the lordship's query as to why the select list was acted upon, that instruction is.
That fine, but why selective acting?
That instruction.
Why this is matter is pending from a long time now for that instruction only.
It's a short time, we will.
Short time, we'll have it at 2 p.m. 2 p.m. You have your
We will
instruction.
try our best, lordship. Let's this.
2 p.m. Mr. Khan, 2 p.m.
Appearing, my lord, he
After some time. After some time. Mr. Nath has some instruction, we'll have it after some time.
For timing, my lord.
May I please, your lordship?
Before my. Can it be taken? The R. Borbuzar will be arguing.
The 22 bigas that you have, there is no dispute. The
Regarding
dispute
that
is with
6
regard to 6
six.
bigas,
which I have applied for your lordship, which
but they have not considered till now.
they have neither rejected it nor allowed it, your lordship. This is a cooperative society, your lordship. Otherwise, not an individual, your lordship. And that cooperative society, your lordship, there is an orchid park in.
Now, this is within forest land.
No, not.
It is a
Your lordship, non-cadastral land.
or non-cadastral land.
Occupied by villagers, your lordship,
For
for.
last 74,
Then,
30,
your lordship, we.
they have given it to you.
They have given it to us, your lordship. And they, without your lordship, deciding our petition, your lordship, they
You
have.
take a call on his
That's.
application, reject it, follow the procedure under law. Evict, whatever you do, but he has made an application. Reject it, allow it, it's up to you.
Let him come.
Mr. Bhattakur, representative. Yes, what happened to the inquiry? Mr. Soma, after some time. Yes, who is appearing for the respondents here?
Today,
all matters waiting for Mr. Nutt. Yes, where is Mr. Dotto? What is this? Nobody is here.
Lord, we fixed on Monday, my lord. Already discussed the matter with the block development officer, my lord. Monday, my lord.
No,
I'll place everything.
what is your instruction?
I'll place everything, my lord.
We had given you time on 1/8.
Yes, my lord.
And have you asked them to inform the
Yes,
respondent by
yes.
8/8?
That is why, my lord, on Monday, my
So
lord,
just give me one. How was this sheds allotted? That's all.
he informed, my lord, that initially some tender was issued, my lord. Thereafter, nothing was happened. Then he was allotted, my lord. The earlier, my lord, as per resolution.
Where is that resolution?
That for that, my lord, Monday, my lord, lordship. Sorry, my lord.
But Mr. AJ Atia, learned counsel for the petitioner, and Mr. S. Dr. learned standing counsel, PNRD department. Dr. submits that the requisite information, requisite instructions from the chief executive officer, from the concerned authority is yet to be received by him. He submits that the matter be taken up on on 8/9/2025, on which date he shall place before this court the instructions received by him. Also, no further adjournment shall be granted in the matter in the event the instructions are sought for are not placed, furnished, this court would consider passing orders requiring the personal appearance of the concerned authority.
Hello.
I'll
What the executive officer Jila Parishad who issued the order.
We'll get it. No worries. जिला परिषद चीफ एग्जीक्यूटिव ऑफिसर बोले कुछ नहीं.
Executive Officer, Jila.
Cut it issue. I have cut it. It's not there.
Yep.
It's not there.
Like,
Hello, please.
Yes. What is your right? Show me.
Uh,
Who are you?
is a cooperative society.
What is your objective?
Their objective is to, they
Maintain a market. For what purpose?
sell products they purchase and
It's a commercial transaction.
commercial.
It's not a cooperative advancement of a cooperative society. You are collecting rents. You are collecting rents and you are surviving. You are not involved in any other matter. And the people who are there, they are just businessmen, not of anything else.
Yes,
And this affidavit was filed way back on 3/3/2023. You have not filed a reply.
on our part.
Para 12, it's very clear. Show me what material you have to counter
But,
para 12, page 79.
But they are, whatever in the society, this is a registered society.
Read that as it may,
And-
it may be.
and there was, my lord, earlier proposal for de-reservation in favor of this society for 3 biga. And
This is a VGR land.
yes, my lord. Then
It will not be done.
then
There cannot be a de-reservation here.
it was earlier my lord, VGR, now it is become a market, my lord.
Where is that de-reservation?
My lord, a proposal for de-reservation annexer.
Proposal
Like-
is different, Mr.
And my
Sikdar.
lord, kindly have a look at the communication of the circle officer, annexer 13, page
Page?
65. The report of the circle officer to the deputy commissioner. Regarding pair for grant of allotment patta. The second paragraph, through investigation, it is learned that it is on records of right that about 3 bighas land unreserved in the name of Kharupetia Agriculture Marketing Cooperative Society Limited. And the said land is in possession of the said cooperative society.
See the last paragraph.
Although there is no record keeping 3 bighas land in the name of cooperative society as unreserved, yet a copy of recommendation of 1956 of the Land Advisory Board in favor of the Cooperative Agricultural Committee.
So it was
Has
just
been
a,
produced.
just a recommendation. Nothing happened.
There was some recommendation of the Land Advisory Board in the year 1956. And my lord, Mondal also given report, my lord. Sir, 14. They should not be outrightly, my lord, turn out and
They will
They-
be turned out by following the procedure of law. That much only.
they have submitted representation before the commissioner secretary to the government. That has not been disposed.
Yes, who is appearing for the revenue? This is an affidavit by circle officer. You come to para 15,
Para 15 of the circle officer.
officer's affidavit, page 79. Internal page 4.
That with regards to the amendment made in paragraph 19 and 20 of the writ petition, the opponent said that the land in question is not required by the government for use at present, but the land would be vacated as and when government requires for any the public at large.
So this one, will quote this, direct them that in the event they want this land, they will acquire or they will take evict you by following the due process of law.
But, and we have also made a prayer before the authority for consideration of
There
allotment.
is no right.
That may also be directed to consider, my lord.
Yes, what do you say? Where is your application?
My lord, my application at Pennexer 74, page 16.
'74.
Yes, my lord. My lord, we are possessing on the land, my lord, since 1950. That part, my lord, they are maintaining their family giving tax to the authority.
That is that Bedokoli tax. That's not Bedokoli Zormina. That is earlier Tozi Bhai.
There are so many, more than 100 people there earning livelihood, my lord. Where they will go? my lord?
But the allegation is very severe against you. Serious against you. Para 12,
There are 12 of.
the affidavit.
The main motto of the marketing society is to realize fair price for farmers' products, but the petitioner, by violating the objective of 32 persons to sit and run various business, and the society is earning sound amount. If there is some violation, they may be restricted. But they are on the land, my lord, since
Like-
1956.
Okay, we'll permit you. We'll direct them to consider your application also. Heard Mr. A.R. Sigdal, learned counsel for the petitioner. Also heard Mr. A. Bachaji, learned standing counsel, Revenue Department, appearing for the respondent number 1, and Mr. M. Chetia, learned government advocate, appearing for the respondent number 2 and 3. The petitioners in the present proceeding have prayed for a direction upon the respondent authorities for consideration of their application for allotment of a plot of land measuring 3 bighas covered by DAG number 1618 of Kharupatia town under Dalgaon Revenue Circle in terms of a recommendation made earlier by the Jurisdictional Land Advisory Board. Also, the petitioners in the present petition have also raised a grievance with regard to an apprehension of they being evicted from the said plot of land under their occupation since long. Also, para. The petitioners in the present proceeding have projected that the petitioner number 1, Cooperative Society, Petitioner Cooperative Society was established in the year 1956. The petitioners further contend that there are around 700 shareholders and some of them are running shops on the land, covering a land over a land, government land, measuring 3 bighas covered by DAG number 168 in Kharupatia town. Full stop. The petitioners have further contended that the land being under their occupation since 1956, applications being made before the concerned authority, such application was considered by the Jurisdictional Land Advisory Board and a recommendation was made in favor of settlement of the land under their occupation, under the occupation of the society. Also, the petitioners further project that the recommendation of the Jurisdictional Land Advisory Committee not having been taken to its logical conclusion, the petitioners had approached the authorities by way of filing representations, one of which was so filed on 11/9/2022, praying for settlement of the land in question with the petitioner Cooperative Society. Also, the said prayers of the petitioner not having been considered, they have instituted the present proceeding with the reliefs as prayed for, with the reliefs noticed, with the prayer for relief noticed herein above. Also, Mr. A.R. Sigda, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the petitioner Cooperative Society being in occupation of the land in question since 1956, and there also being a recommendation from the Jurisdictional Land Advisory Committee for allotment of the land in favor of this Cooperative Society, the respondent authorities could not have kept the matter pending and ought to have taken the recommendation to its logical conclusion. Mr. Sigdar has submitted that the respondents, that the petitioners being a petitioner being a cooperative society, public interest is involved in as much as the land in question is utilized for the livelihood of its members who have set up shops therein for the set up shops therein for dealing with farm produce. So in the above premises, Mr. Sigdar submits that the respondent authorities, more particularly the respondent number 1, be directed to consider the application dated, the representations dated, representation submitted by the petitioner, including the representation dated 11/9/2022. Per contra, Mr. M. Chetia, learned counsel for the government advocate, appearing for the respondent number 2 and 3 by referring to an affidavit filed by the circle officer, Dalgaon Revenue Circle, has submitted that on a local inquiry made, it was found that the petitioner society had violated the objectives of a cooperative marketing society. So it is contended that the main projected motto of the cooperative marketing society is to realize fair price for farmer produce. However, the petitioners, by violating the objectives of a marketing society, had permitted about 132 persons to sit and run various businesses, and the society is earning a good amount from them as monthly rent. So accordingly, he submits that the society not being operated for the motto it was so set up, the prayer of the petitioner society would not mandate an acceptance by this court. Mr. Chetia has further submitted that there being no direction received from the competent authority, the circle officer, jurisdictional circle officer, as well as the district administration are not in a position to allot the land in question in favor of the petitioner society. Also, I've heard the learned counsel for the parties and perused the materials available on record. The facts noticed herein above are not in dispute. Also, however, the petitioners have projected that they are in possession of the land in question since 1956, and also there was a recommendation for settlement of the land under their possession by the Land Advisory Committee. However, the said proposal has not been demonstrated to have been taken to its logical conclusion. Also, accordingly, the petitioners as on date can be only deemed to be encroachers of the said plot of land. Also, further, the contentions raised by the circle officer, Dalgaon Revenue Circle, in its affidavit filed on 3/3/2023 has not been countered by the petitioners by way of filing a rejoinder. Also, the circle officer in his said affidavit in para 12 had contended as follows. Para 12, page 79 of a Kutkuidiva. Also, a perusal of the said affidavit further goes to reveal that it is the stand of the respondents that the land in question is not presently required by the government for his use. However, in the event in future the land is so required, the petitioners would be vacated therefrom. Also, in view of the said position, this court is of the considered view that the present writ petition need not be detained any further. Also, the petitioners herein are granted liberty to file a fresh application before the respondent number 1, that is the Commissioner and Secretary to the Government of Assam Revenue Department, praying for settlement of the land in question with it. Such application be filed within a period of 15 days from today. So in the event of filing of such application, the respondent number one and or any other authority competent to consider such application shall consider the same and dispose of the same by way of a speaking order. Full stop. It is further provided that in the event in future the land occupied by the petitioners is so required by the government for any public purpose, the petitioners shall be evicted therefrom only by following the due process of law. So with the above observations and directions, the present writ petition stands disposed of.
People.
Yes, Mr. Nutt, what is your instruction? Have they been given all the benefits required?
I have received an instruction, but this the instructions of the I'm not
Mr. D. Nutt, you just informed Mr. Rabha also. Oh, Mr. Rabha. Mr. Rabha, his instructions are not very clear. So let him complete his instructions. We'll take it up after some time. Heard Mr. U.C. Rabha, learned counsel for the petitioner, also heard Mr. D. Nutt, learned senior government advocate Assam. Mr. Nutt submits that the instructions as received by him are not complete and accordingly prays that he be granted time till 17/9/2025 to complete his instruction. Prayer accepted. Registry to list this matter again on 17/9/2025, on which date Mr. Nutt shall apprise this court with regard to the instructions as received by him in the matter. Yes, Mr. Nutt.
On the first call, I was not there.
No, it's okay, Mr. Nutt. Yes, Mr. Nutt, who is appearing? I think you are appearing. That supply order.
Yes.
Rupai Development Organization.
Now, your lordship will see the paragraph number 4 of the affidavit filed by the director at page 2.
Who is appearing for the respondents here?
The affidavit has been filed by the director of social welfare. So if your lordships looks at paragraph number 4, they may have raised some issues about the legality or the illegality of the contract.
Mr. Moore,
Yes.
you are basically basing your arguments on section 70 of the Contract Act.
On the doctrine of quantum meritum.
Quantum meritus, and that you have not done the work gratuitous.
Yes.
Right?
That's your lordship is right.
But there is a dispute with regard to the very factum of supply.
That is not, they have not disputed. They have only said.
No, the very way you have come in, that is under dispute. The work order that you have relied upon is of some Prabhati agency.
Maybe.
So how can we permit you?
It is not the first time, Malad, this has happened. When you invoke the section 70 and when you rely on
To
whatever
invoke
reason.
section 70, to invoke section 70, there has to be some legality somewhere.
Yes.
You can't just walk in, do something and come back and say that pay me. Just for my clarification.
Yes. I was also wondering in the morning today. For any reason, but say here they say that it was allotted to A, but it was given to B.
No, they say that it was never given to you.
That's the stand of the director.
So tomorrow,
That's the stand of the director.
tomorrow, Mr. Kumar,
Yes.
if this is the law we lay down, there is a road passing by, it's been bad shape. We decide that we will build it and we'll ask the government to pay me.
No. The government has, here the department has received the material. It is not
Fine,
the case.
But
that the
that
when
receipt
received-
was not from a legal source.
But the concerned department at Tinsukia, if it received it and if it acknowledged the receipt, then your honor, then your lordships can.
But that would
directly-
be giving premium to an illegality.
In that case, my lord, we have to look into the Supreme Court judgment on what it says. A,
Yes,
B, and C.
please, please.
My lord, today I give the citation to the copy to them also and to your lordship only. Also, your lordship, may I have the.
You have relied earlier on one decision of Pilu Donchi Sidwa.
Now there are better judgments to look into it.
Please.
But I will request your lordship that your lordship will look into it. I will also look into
Because
it.
this is
once again.
something which I'm finding very
Yes.
interesting.
Yes, my lord. Your lordship, I will given this. But I would also require some time to go through each and every line of the judgments. Because last night I came very late.
Okay.
So my eyes are just pulling me
No,
down.
no, it's okay.
So your lordship will fix it. We'll hear it on any other day. Madhyas. Ranjita did you. The others laws are because we have now.
Because, say, Mr. Mori, there is no pleading on your part that before effecting this supply, there was an agreement entered into. It seems that you came from A, there might be some nexus with somebody there. This is something which is troubling me.
Yes, ma'am. That will trouble me also, but we have to go what the law says in the judgments and the other doctrine where this doctrine of quantum meritat has been applied. We'll reflect on it. Your lordship I'll also try to give a proper.
Means you are trying to project that it is an illegal appointment, but I having worked.
No.
Give me the money.
No. It's that fact situation and the fact situation here is
But
different.
how did you make that supply, Mr. Kaur?
The department asked me to make the supply. I made it.
But that they say is a fake document.
No.
And that is why an
that is
inquiry. What happened
direct-
to the inquiry, Mr.
That
Nothing but
latest.
the inquiry. Otherwise, my lord,
No.
my lord,
Amount-
No,
because
fine. Maybe.
said,
See, there are case laws which says that in the event you have received the supplies, then you will have to pay him the fair value. That
Ideal
means the ideal value. But here, your affidavit goes to a certain extent, but it does not go to the full extent.
Yes.
You have not even made an averment that the material were never received by you.
That they can't do it because their officers themselves have said that we have received.
And if the officers have received the material, whether you have taken some steps against them.
that is one part. Those instance, those are made without order. How
This
can-
is a very dangerous situation, Mr. Nath. Tomorrow, anybody can walk into PWD office, make a supply, say
Yes,
that, no,
yes.
no, I have an order, give me the money.
Those are factual disputes that because lot of facts are there, they have to plead and prove.
No, what he says is I
Simple.
got a
Walk on.
work order.
There is nothing
I'm-
there.
I got a work order, I made the supply.
And you received it,
You received it, you pay me.
the ideal amount.
Now, not paid, he comes up. Now you here, you say that the work order itself is fake. But what happened? What about the goods you have received? The goods,
And that-
supplied goods.
and-
What happened to that? Did you return it to him? Or was it seized by some investigating authority?
Those were received by the properly utilized.
But
No.
that contention is not dealt with. You see, look into it.
Yes, we'll see.
The
We'll see.
expression used for this type of receipt is a case of unjust enrichment. That's why the court invokes quantum meritat, that in case of unjust enrichment also you have to pay if you acknowledge the receipt. It's like getting into a rickshaw.
I'm sorry, Mr. Kumar,
We'll-
tentatively passing that direction would be dangerous.
No, we'll hear it. My lord. It's like getting into a rickshaw, and if you get down from the rickshaw and you say that you didn't tell me that if I get into the rickshaw, I have to pay.
You first place, you forcefully got into the rickshaw.
No.
That poor man had to forcefully take Mr. Kumar.
Oh, no, my lord.
Whereas he was not
Well,
even.
we'll deal with in an
Okay.
auspicious day.
Okay.
Let him come up with the full
There
particulars.
can't be a more auspicious day than today. Ganesh Chaturthi.
Well, let him come with full instructions, my lord. Lordship is negate the last where the affidavit stopped because it's a matter of 2016.
Heard Mr. B.D. Learned, Senior Counsel appearing for the petitioner, and Mr. Dina Learned, Senior Government Advocate appearing for the respondents. Mr. Dina Learned, above the parties to the proceeding have submitted that the matter be taken up for final disposal on a date to be fixed, on any date to be fixed by this court. So,
Required.
Yes.
Mr. Dina, Mr. Dina,
Further instruction.
Learned Counsel appearing, Learned Senior Government Advocate submits that he be granted 2 weeks' time to complete his instructions in the matter and to make his submissions. Also, prayer accepted, a registry to list this matter again on.
Subject to your lordship's convenience on 25th of September.
No, that week we are not touching. The week before.
Oh, my lord, then on 19th of September.
18.
Well, 18 I'm in Kolkata, my lord. That's
16.
From 14 to 18 I'm in Delhi.
Then we'll have it on 11th.
No, this two
19, 8, 19, 9, 2025.
I'm obliged.
Mr. Nutt, please look into this. Otherwise, this proposition of law would be very dangerous.
Dangerous, my lord, lordship.
We'll test
Otherwise-
it.
otherwise-
But your lordship will test it.
Anybody will come up. my lord.
Walk and then you will be, there has to be some semblance of a power or an authority. But let's see. Ma'am?
Fine.
Yes, Mr. Barbuzari.
Lordship,
Mr. Barbuzari, what happened to the application of the society for settlement of that land with them? These actions have been taken by the district authorities, which is impugned here. As a revenue department, what is the stage or status of that processing?
That information, my lord, we
Because if you are accepting that land, if you are accepting his proposal or his prayer, then this matter need not be gone into.
and he is in.
If you are not accepting, then we will have to see as to whether he was being sought to be evicted in the manner known to law. The division bench clarification is there. Talaquddin is there. 18.3, 18.2, both would require a notice. This much you get us what happened. Where is your application pending now?
Your Lordship, that is before the Deputy Commissioner, and to my knowledge, Your Lordship instruction, they have not passed any order on that.
It has not been forwarded to the government.
Nothing, Your Lord.
Mr. Bharpuzari, if it is before the Deputy Commissioner, how will you get it?
It is before the subdivisional officer Bokakhat.
Kahat.
Submitted application, here, page 28, Your Lordship. That is my report.
So what has the Deputy Commissioner done with this? He can't take a call. He'll have to forward it to you. So you have your instructions. Because this is not a personal thing. It's a society, cooperative society, and they have a museum for a particular community also there. And this land literally was in occupation of that community. Gurkha community. And they are there for, what they have projected is that they are there for a long time. $22 was allotted,
Okay.
6 odd they had got from people who donated it to them, or the possession was transferred to. They can't donate, the possession was transferred. So they are literally in the shoes of those possessors who were there for a considerable period of time, and you have not denied the fact that these people were there for a long period of time.
22 and 6.
6.
So for 22,
They have now, you can do nothing.
so for is concerned, my lord. The 6, my lord, since it is a contiguous plot of land, they have jumped into it. That is the.
No, they have not jumped into it. They have been invited into it. Anyway, you look at,
Your lordship may kindly go through
Part
the
say
page
not
43, report of the subdivisional officer, your lordship.
First say,
Page 43. This is a report by the subdivisional officer.
finally come to the last slide. Thus it is found. This is the dispute.
Purposely, make a verify as to whether this land were encroached upon by the society on their own, or that the land was already encroached by XYZ, who had permitted this land to be occupied or transferred the possession of the land. They can't transfer the land, they transfer the possession. Nothing is in. And also that the, if you want to evict them, the purpose for that.
My lord, that they are in having no.
I got it. I got it. But if they have on their own and gone and encroached upon that land, it will be a different ballgame altogether. It was vacant land, they went and encroached upon it. But if that land was already under encroachment and you had no issue with that, and those encroachers, no right basically, had transferred this to them, what would be the situation? Fine, but the encroachment is permissive because you have permitted them to be there for such a long time.
In fact, the entire area, your lordship,
Is under encroachment.
under encroachment, your lordship. No patta, nothing, but people are, your lordship.
Where is this situated?
It's just near your Kohora, your lordship.
Pohara.
In fact, your lordship, it is adding value addition to the Kaziranga National Park, your lordship. Thousands of people visits your every day, your lordship. It's a highly successful endeavor, your lordship. That by
Now I've seen that some endangered species of orchids have also
orchids
been
are-
brought there. It's a good thing. Okay, Mr. Borpujari, you complete your instructions. But bring on record something solid.
Whether here or there, my lord.
Because this is not an individual who is involved here. It's a society, basically. Okay. But Mr. S. Bhattakur, counsel for the petition. Also heard Mr. R. Borpujari, learned standing counsel, revenue and disaster management department. Mr. Borpujari submits that he be granted 2 weeks' time to complete his instructions in the matter. Also, Mr. Borpujari further submits that he would also apprise this court with regard to the status of the application submitted by the petitioner for settlement of the land of the land measuring 6 biga 1 kata 12 lesser found to be in possession of the society in excess of what was originally contemplated for the society. Also, registry for prayer accepted, registry to list this matter again on 4 weeks, 4 weeks, 4 weeks, 4 weeks. What 4 weeks, followed after 4 weeks on a date to be fixed by it. If it doesn't come, make a mention.
interim order shall continue.
Interim order passed earlier to continue till the next date of wisdom. We'll not keep this matter anymore pending. You get your instruction, we'll finish it off.
I'm obliged, my lord.
Yes, Mr. Nath, what is the development?
From the authority, I have received a letter. Today, but some time maybe
But have the records been taken over?
letters I have received, one from the, the deputy commissioner. for the report, but that record, whether they have got the.
Mr. D.
not
Nath,
clear.
learned senior government advocate, submits that the instructions received by him in the matter is not complete, and accordingly he prays
Report is
that
awaited.
the
First report.
matter be taken up on 15/9/2025, on which date he shall apprise this court about the status of the inquiry conducted by the revenue department in the matter. Yes, Mr. Nath, what is this? Oh, Mr. Chaudhary, you are there. Yes, what has happened? Why the money is not being released?
Lordship,
Any dispute with regard to the money? With regard to the work done?
Lordship, work with regard to the original work, he has been paid.
It's for the additional work.
Beyond the scope of that NIT, Lordship, he has not done it. The said work has been done by another person.
File an affidavit.
Yes, Lordship, that verification that I not complete. The clarification that I saw that came in that Lordship, it was done by another person. Through
Not by him.
Not by. The tended work was not sanctioned.
This is again says he has done it in verbal instructions. There is categorical statement made and materials brought on record
Yes,
in the.
was initiated, but since there was no.
If he has done the work,
Lordship, that's why, Lordship, further after a week, Lordship.
No, I want an affidavit now.
Yes, Lordship, I will bring it on record.
The materials on record shows that it was done with the concurrence of the departmental authorities. Mr. B. Chaudhary, learned counsel for the petitioner, submits that the instructions in the matter has been received by him, and an affidavit on behalf of the respondents represented by him would be filed on or before 11/9/2025. Registry to list this matter again on 17/9/2025.
Availability of that permanent structure.
Why? What was the purpose for the demarcation?
For whole area, my lord, area has already been
1219 and 1220.
they are seeking help from survey team. Sent to them on 28th of July, but they are yet to respond, my lord.
Okay.
Will shortly.
Your land is 1220 or 119.
My lord, 1119 loss, 1219 loss.
1219. And the government land is 1220. So your categorical case is that you are occupying your building, everything is in 1219.
Yes.
That much only.
Now,
Who are you?
We come off.
Who is responsible for?
Problem is that, my lord, revenue authority did not come, my lord, municipal board come, my lord.
Municipal board cannot do a the
That is
demarcation.
the problem. The construction permission was granted, lawsuit, approved plan is there, kindly see page 47 lawsuit. Page 47, this is the approved plan lawsuit.
There is no, my lord, scope of, my lord, deviation.
Okay, for 47, where is 47?
Page 47. My lord, X,
What is the DAG number
Right
given
side.
there?
1219. Sir.
Okay,
Right side, kindly see, this is the land lordship. My lord, one side is, my lord, natural drain, other side is PWD route. Corner is my land, my lord.
okay. Mr. Ahmed, what we propose to do is, we'll direct the Deputy Commissioner to make a demarcation involving you also in the matter. If it is found on demarcation that the building is standing on DAG number 1219, no further action would be called for. But if it is found to be standing on 1220, by following the due process of law, even for demolition, they can proceed.
Now, my lord, let affidavit come, lordship.
Why affidavit?
My last order directed to file affidavit.
Fine, forget affidavit. There is a demarcation required. They let them make the demarcation in your
Also,
presence.
my land also should be demarcated.
Yes, 1219, I'll make it
Yes.
specific.
Lord.
That if your land is found to be within DAG number 1219, they will not touch your property.
Before
But
that,
if
Lord,
it is
kindly
found
see.
to be within 1220,
Yes.
demolition, whatever one they want to do, they can do by following the due process of law. You agreeable to that?
My lord, before passing order, lordship, kindly see, my lord, page 45, lordship.
45.
Page map, lordship.
Okay.
This is the, my lord,
Why should I go? I am only concerned with your concentration that you are in 1229.
1219, lord.
1219. That
My lord,
much
that is
only.
why, lord. For my lord, factual position, lordship.
Hmm.
I want to, my lord, draw your lordship's kind attention, lordship. Kindly see, this is the land, my lord, 1219, 1220 is the drain. Left is left is, my lord, this is a PWD route. Now, the permission of construction, permission was granted, next page 46, lordship.
Hmm.
As per the-
1219.
Yes, lordship. As per
So
the-
what
as-
we, Mr. Ahmed, what we propose to do is that everything is in 1219.
1219.
And in the field also, if it is found after demarcation by the Deputy Commissioner to be within 1219,
Yes, lord.
they'll not touch your property.
Now,
But if it is found to be within 1220,
Lordship.
they'll demolish it. That's all.
my lord, now page 46, 47 is very much clear, lordship.
1219.
Yes, lord.
1219.
1219, lordship.
That's all.
And the 1220, 1220 is not, my lord, is a back end lab. This is, my lord, drain.
Mr. Ahmed, that's what I'm saying. Let the demarcation be done by the
Yes.
Deputy Commissioner. And if it is found that your building is within 1219, they'll not touch it. But if it is found to be within 1220, they'll demolish it, evict it by following the due process.
That is, my lord, a matter of, my lord, the department, revenue department. lordship.
That's all. Are you agreeable to that order?
My lord, demarcation may be, my land should be demarcated, lordship. I also submitted application. lordship.
Everything will be demarcated. Everything will be demarcated.
I also submitted application for demarcation, lordship.
Where is your application?
That is not annexed, lordship. Copy is also not, as for instruction, I have submitted, lordship.
Hmm.
If that is, your lordship, permits time, lordship, I'll annex that copy.
No need.
Submit that copy, lordship.
Madam, how long will it take you for you to demarcate this property? If it is already been demarcated, how come? And how can you know? You're a municipal board only. Whose property, where, what DAG number, you're not supposed to know.
Yeah.
The demarcation process is on now.
That they have
I
carried out
directed
that
to file affidavit.
That they will give. You have got nothing here. You are only concerned with the building. If the building is not constructed in the manner it was approved, you can demolish it. But if the building is in 1219 only, how can you touch it? How can you touch it? Much only. You are paying for whom? Yes. What time? How much time will it take? Ms. M. Burman, learned government advocate, appearing for the Circle Officer, Dalgaon Revenue Circle, has submitted that the demarcation of the plot bearing plot bearing patta number 478 under DAG number 1219 from the other plots of land covered other plots of land surrounding it covered by DAG number 1220, 1218, 1213 and 1227 is under process. She submits that the said demarcation exercise would be completed within a period of 6 weeks from today. Also, in view of the above submission of Ms. M. Borman, registry to list this matter again on (19) 9/2025. Also, it is provided that the authorities, revenue authorities, shall proceed with the demarcation exercise. However, the possession of the land shall not be disturbed till the next date of listing. Full stop. A report with regard to the findings of the with regard to the completion of the demarcation be placed on record before on the next date of listing. Registry to list this.
My DAG number may be mentioned, Lordship.
1219.
1219, Lordship.
Patta number 478.
Yes, Lordship.
Registry to list this matter, human question. 19. Human tarifale deputation moito. Putoro question again. 17. Or kiman 19 question, 19 9. You give me bring a report, but don't disturb the possession also. And mark it. Pillars. Yes, Mr. Professor. What has happened to the proceedings?
Things, they have, the petition has been filed, and because of that, now Captain Evans. Not doing anything, Malad.
Madam, you go and make your submissions before this. That the hearing is complete.
Lordship, here, before the competent authority come up with this notice under section 6(8), they first have to comply with the mandatory compliance of 68E, where an investigation,
Madam, that report is already there. You have not responded. The reason to believe is in page 31. There you find that the investigation was conducted in terms of that provisions of section 68.
in the morning, I prayed for some accommodation.
And now I got the answer. Okay. On the prayer of Ms. C. Som, Learned Counsel for the petitioner, registry to list this matter again on 2/9/2025.
I'm obliged, Lordship.
And madam, the hearing is not concluded. You'll miss the bus if you don't go there. And your additional affidavit is neither here nor there. Your additional affidavit does not show the source from where you have got the money. So the suspicion is there. Go and remove that suspicion. Okay. Mr. K. Parasar, Learned CGC, appearing for the respondents, is present.
I'm obliged, Lordship.
No further hearing, go ahead.
12 and 13.
Mr. Mishra, can you get hold of Mr. Pathak so that we will not keep you waiting? Yes.
I have filed my affidavit, my lord, yesterday, my lord.
Not on record. What is your stand there now?
My lord, I have enclosed the documents as regards the manufacturer's, my lord, trade license. My lord, I have enclosed.
Is it a license, the
TMC authority has issued.
license to that?
Yes, Uzbekistan.
And you are Uzbekistan, you are using Uzbekistan.
Yes.
And they have issued license for motorized
Yes,
rickshaw.
because my lord.
Just show me.
Assess. Is my lord, 112 is the my lord, trade license.
Oh, trade license is
No,
different.
no, my lord, that I am coming, my lord. That lordship will find it, page 117. And with motor lordship will find that,
Where is this motorized? Manufacture of non-motorized bicycles and including cycle rickshaws. Invalid carriages with or without motor. This is not that. You are a tricycle manufacturer. Where is that license?
motor. My lord, page 118, serial number 3. Manufacturer in valid carriage with or without motor.
Manufacture of bicycles is different. Tricycles.
Tricycle word, my lord.
This is a certificate of 11.4, right?
Yes. My lord, page 118 is certificate dated 11/4/25.
20?
25. Top, my lord.
Yes, Mr.
Number 2. The certificate even I regarding
That, my lord, that can be, my lord, controlled, my lord.
This is only with regard to Uzbekistan or something. What
That, my
about
lord,
the others?
That rickshaws, my lord, the petitioner.
Okay, what about the others? Mr. Bhuya's rickshaws are other rickshaws.
Yes, my lord.
The learned counsel for the learned counsel for the parties have prayed for further 2 weeks' time to complete their pleadings in the matter. Also, Mr. Bora, learned standing counsel, GMC submits that he, in the meantime, be permitted to complete his instructions. Also, prayer accepted, a registry to list this matter after 2 weeks on a date to be fixed by it. Ms. M. Bora, MD Bora, learned standing counsel, transport department is present.
My lord, the interim order passed earlier.
Interim order passed earlier to continue till the next date of listing.
Right.
Mr. Sharma, you are appearing for? Who is that? Uzbekistan, okay. Mr. R. Sharma, learned counsel appearing for the respond number 8 in WPC number 1648/2023. Ms. MD Bora, Standing Counsel, Transport Department, and Mr. R. Sharma, Learned Counsel, representing respondent number 8 in WPC number 1648/2023 are present. Interim order reported interim order passed earlier to continue till the next date of listing. Interim orders passed earlier. Interim order passed earlier in the above noted writ petitions to continue till the next date of listing.
In this case, my lord,
Yes, Mr. Doctor. What is, why, in spite of orders passed by this court, such a course of action is adopted by you? 39. Yes.
Last para.
Hmm.
The above circumstances, the TS number so and so is pending before the the holding in the name of the applicant Nirmal.
Is there an injunction?
Injunction is not there.
Then? And this court has also said it will be at his own risk.
Still, my
It
lord,
will be at his own risk.
yes, yes.
So how can you now bring in a condition over that?
The cost of that is
That's what is being projected since the day one, but we don't see any remedial action being taken.
the lordship may see this honorable court passed an order at page 35.
Hmm.
Respondent number 3 thereafter instituted final consideration. Order of the learned munship was up.
Hmm.
That would be at his.
So there is no bar in you giving, then why don't you do it? That will again be subject to this, the title suit.
The lordship may give
Why should I?
further observation.
Why should I? Why should I? Why your understanding is,
In my
why are you
understanding-
trying to overreach the orders of the trial court?
Correct. Order passed is not in.
Mr. S. Dr. Learned Counsel for the respondent. Yes, Mr. Mahmood.
Don't think your lordship is.
No, we'll hear him. Mr. Mahmood is here. Why? How can we even dare to say that we will not hear him?
First thing, my lord,
Yes, Mr. Mahmood.
there is serious question of law.
Yes.
Matter is pending before the court,
Yes.
whether the authority is entitled to pass any order.
Okay.
Now, kindly see page 33.
Serious question of law is whether
Yes. Page 23, sorry, page 23. Top, with the observation that landed Municipal number 3, Kachara Silchar may expedite
page
the
23.
of their petition. Kachara Silchar may expedite the proceeding in TS number 39, 2013. Court finds no justification at all in issuance of the impugned communication dated 5/12/2018. Accordingly, the same said status a request. Applicant may approach learned civil court to proceed with the civil suit expeditiously. Interlocutory application and related writ petition are accordingly disposed of. Now my submission is this, my lord. When the applicant perhaps my learned friend.
my lord, earlier in this round of litigation, when the municipal authority, my permission for construction was objected and not granted, then
You came up.
yes. And he has came up. He has
The
came
Mr.
up.
Mahmood had
When
come.
he filed an IA for modification of the order, then entire writ petition was closed.
That that is my question. This
By
Title-
allowing, by passing this order.
first thing, my lord, the this was filed, this title suit was filed by
Construction.
the private respondent. Now, our submission is this, my lord. The law is the, my lord, this is, or there is, at first I said that there are serious question of law. Law is the last order passed by the last judge. Law is the last order passed by the last judge. Now, the last judge is this. Now, last judge was, what does say? It's, last judge says.
No, it's not the
that-
last judge.
Okay, law-
As far as the single bench is concerned, I'll be the last judge.
Yes.
I'll pass the order.
No, your lordship has not yet passed any effective order.
I'll pass the order today.
But your lordship will pass the order after showing the, my lord, there are several judgments of the Honorable Apex Court that when the matter is pending before the higher authority, the authority, that authority may be executive or judicial or any other, they should not pass any order. Now, when the Honorable Court, that is page 23, is clearly saying that, clearly saying that the applicant may approach learned civil court to proceed with the civil suit expeditiously. Interlocutory application and related writ petition are accordingly disposed of. Now, my lord, my submission is this: the Silchar municipality has passed the order. Now, when the Silchar municipality has passed the order, and the court says that he will approach before the civil court, his application, he was the applicant there in our title suit. He did not go to file civil suit as ordered by the Honorable High Court. Instead of that, he has taken a shortcut way, thus he has come to the High Court and has sought the remedy. My submission is there are two brothers. This Nirmal and they are own brothers. Question of disputed.
Want to resolve the issue? We can send you to mediation.
Better.
That in the before the trial court that fails.
Failed. Forget it. Responding to Mr. Two Brothers,
I think-
that love that I was seeing. That's why I said Mr. Mahmood, there was an observation by the learned trial court that he can make construction alteration.
Of the High Court, what I have said.
There is an observation in the revision petition which was filed by you against the orders passed by the trial court. Now, this order is not modified till now.
Filed by him.
This order, which is there in CRP 302/2014, is yet holding the field. It has not been modified. So if that be so, this land, whatever happens, finally in the title suit, whatever in the meantime he gets will be subject to that. So why the holding numbers are not being given?
That is true. That
Then if that is
in the
true,
long
then
run,
there is no
that
question of law
decided.
required to be considered.
Party, but if he allowed to have a separate holding, then that will be subject to the result of the
Naturally.
order. That I understand, but why that would be given?
Why it should not be
I am
given?
his own brother. I am his own brother. And the court says that he
See,
will go to
Mr. Ghosh, how much love he has for you. And you are contesting these matters. Bad.
I am his own brother. I
It's
am his
oozing
own-
out of Mr. Mahmood, the love for you.
He has also loved.
Oh, he has also love. Now,
Definitely.
then
I
we are
cannot
passing
say
the
after
orders.
all their brothers.
Then we are passing the orders. Anything done will be subject to the outcome of the title suit.
Yes, that is one aspect of the case. Other aspect, my lord. Your lordship kindly on that point, there is apex court judgment that when the matter is pending in the High Court, the executive authority or any other authority below the High Court or below the Supreme Court, if the matter is pending before Supreme Court, they cannot pass any order. That for that your
Now the matter is not pending before the Supreme Court.
No.
So I can pass orders here.
pass order, but my interest may be protected.
It's already protected. Anything done with regard to that building would be subject to the outcome of the trial court.
That he has not gone to Supreme Court, Civil Court, that what is the?
That is up to him. That is up to him.
Not up to him. The Honorable Court has given direction, him.
Mr. Mahmood, we can only observe. Going, no going, is his. Whatever consequences will follow, he will suffer. Why should I?
He has not gone to Civil Court, though directed.
He had the direction that you are referring to at page 23 is to him to appear in your suit and pray for its expeditious disposal, not for him to institute a suit.
The Civil Court. The Civil Court shall not be, shall not be no bar for the Civil Court.
Naturally.
Decide the matter.
Naturally.
Any observation of this Honorable Court today.
Not today, any time will be subject to the final conclusions arrived at by the, will not sway the learned tribunal.
Shall not be praise the order of the, that may calculate.
I'll do it.
Civil Court would not be bound by any observation made today.
Look, at 2 o'clock we'll pass the order. That is it, Mr. Go back. We'll say that this is bad. Whatever steps is to be taken with regard to that building, there being no restraint order, you're free to take. However, everything will be subject to the decision of the trial court.
Observation already there. No.
Oh, you want something more?
After that.
That already there in the.
No, I'll make it, I'll reiterate it. Will I be committing any wrong in that thing then?
Lord, I have already instructed them.
Wrong. We'll not put it in your mouth. We'll pass that on.
Maybe wrong or right, but ultimately I will be affected.
So there is, Mr. Mahmood, this court can be spared from answering the serious question of law in this matter. We'll keep it reserved for some other matter. Or we know how to get it respected. Mr. Mahmood, so no question of law being framed. It's only on facts. You're sparing the court from. I'm keeping it for some other issue then. At 2 o'clock, we'll pass the order. We have a matter. We'll spare Mr. Mishra and then we'll get back. Mishra Sahab, matter.
Okay.
Anything more, sir?
The instruction is the application of mine, because here if you look.
I'm happy that you are here, but I would not have been sad if you had also addressed me from the online.
I actually like, but sometimes my lord,
I know that's what, there is no bar. Please don't take it that
No.
only there is nothing.
My lord.
Hearing you is what is required. Yes.
My lord will kindly see the instruction.
Hmm.
The instruction, if your lordship has gone through, they say that the capacity of the transformer that was bypassed is 750 kVA. It's a written instruction.
It's at the top after the.
So the order it is there. My lord.
No, it's it.
On that, your lordship passed order on 14/8.
Yes.
If your lordship will see the order, reference to subject.
Till of 11th of August.
It's right below the order, I'm told.
No, it was, yeah.
We have a copy below.
No, it should be here. It should be here. It could be. Those 2-3 pages. You have a spare copy?
page
139, yes.
Yes. The next page, your lordship will see serial number 12 at 140. Tea, coffee and rubber.
200.
So estimated consumption is 200. So as I have shown, they have taken the full capacity of the transformer, 638, and they have multiplied it by 200 and then other charges. Now, when this was, this is a lot table under 6.2.1.1 and connected load. And connected load is 938. Not
total connected load.
Total, yes. Because total connected load is to be taken into consideration. And my lord, therefore, the learned appellate authority, if your lordship will turn to page 63. 63. The paper book. Eighth line from the top. Therefore, in my considered opinion, due to the said malpractice, the assessment of total energy consumed by the aforesaid seasonal industry as per guideline in 5.A.4.4 of the Electricity Supply Code, regulation AERC should be made for the first instance on the total authorized connected load of 908. So this is in accordance with the rules, the supply code. So they cannot take it the full capacity of this thing. That was what the appellate authority said. And later on, they corrected, my lord, after this order. Your lordship will find at page 67. They corrected it. 66 is the covering letter, and 67, if your lordship will kindly see, total connected load there, your lordship will find 938 at page 67.
Yes.
Then below that, if your lordship will see, bypass load at factory. This is what we are concerned. Assessed unit, connected load into assessed unit. Your lordship will see for 938. This is for 9 months. Should have been for 8 months. Now, so 938, they have corrected the calculation. And when lordship sought for instruction, they are saying the calculation will be on the full capacity of one transformer. One transformer, yes, that is the transformer which has been bypassed. What we are saying is that when you are taking the total connected load of 938, and admittedly, 938 kW is being supplied to the factory by 2 transformers in equal proportion. Both transformer of 750 kVA. So therefore, you charge only half of the full capacity and then 200. Because spare one. All that I'm saying is spare.
You want that this 938 should be 938 by 2.
By 2, because only one transformer was affected. The others was not.
But there is that instructions if we come back.
Yes.
Although the
100%, that one your lordship is saying.
750 kVA, both were giving you, one was giving you 638, total is 930.
That will be absurd because
that's what I'm not getting.
If they say that one transformer is giving 638, the other is also giving 638.
Cannot be, because
Then
total
12
cannot be cannot be more than 938.
Yes, then it will be 1,200 something.
Oh, for you it's easy, but for me to get it, I'm not getting it. That's why I'm asking you.
Capacity which was
The total connected load is 938. 2 transformers.
because one cannot meet that. One individual transformer cannot meet that
Needed.
much
So there will be 2 transformers.
transformers.
So both the transformers are 750. 8.85.
0.85, it becomes 638.
Fine.
So we have taken the maximum capacity of the transformer.
But you have ignored that one of the transformers wherein there is no malpractice was also supplying.
Was also supplying.
So you will have to make a provision for that also. You can. What is your loss? You can always recover into 200.
Yes.
But when you come to this figure of 938, how can you say that one transformer is running or deemed to be running 638? So other one is only 300. Whereas the load factor, you may be correct if the load factor was taken.
Load factor was taken. Perhaps it may be the other way around also.
It can be.
Yes.
But today it's a presumption. Presumption. So the presumption is there is 938. You are saying the one which was bypassed was having is consuming 638. Or the average that was it was discharging 638. Whereas the other one was working for that same period. Have you made an assessment how much energy was consumed through that?
No, that was not done.
Then?
Lordship, we have assumed that this transformer which was bypassed, that was not done.
Mr. Pathak, if that was not accessible, that factor was not accessible, then your presumption may have been proper. But that was a data which was already available with you.
So a survey had to be done.
With regard to the first transformer.
First transformer, it was not done.
It was there. So you could have found out that this is the consumption there. Maybe it's 200. So 938 minus 200 would be 738. So this can be 738 also. 638.
In one aspect, your lordship. Lordship has the provision high code. 5.8.4.4.
5.8.4.4.
When a consumer indulges in theft of electricity, the officer authorized in this behalf by the government of Assam, without prejudice to its other right, will assess the quantum of this consumption of detected category as per table under. I'll take a pause here, your lordship. This has a direct correlation with section.
Electricity Act. Yes, 126.
26.6, your lordship.
Assessment made under.
Assessment under this section shall be made at a rate equal to twice the tariff. Kindly note the tariff. So in order to determine the tariff, what has been given to remove the arbitrariness out of the entire system, because otherwise it's supposed to be a best judgment assessment. Reference under clause 5.8.4 is made to a table under 6.2.1.1.
We can have it at 139, yes.
Here, your lordship, the maximum connected load of the consumer is to be depending on his category, is to be multiplied by 200 in the case of the present consumer. Here, actually, your lordship, the proper calculation as per the supply code and the Electricity Act, we should have multiplied it by 938. Both the transformers ought to have been taken. It's not envisioned either under the supply code or under the Act that when you bypass one transformer, because you have not taken the trouble of stealing electricity from the other one, you are excused. It has to be done at the total tariff, which is applicable. And how can we arrive at the total tariff? By only determining the total of the company. The total
Because it also is in a form of a penalty.
Penalty.
Okay.
So instead of doing it for 938, at the very outset, they made a mistake by taking it only for the second transformer. Because that is not envisioned. And then that mistake was compounded by the appellate authority. He has now taken another separate formula, which is neither under the rules nor under the Act. There is no provision for any off-season demand or peak season demand anywhere.
But you have complied with that.
Have complied with it, but there was no provision.
Fine.
Yes.
Mr. Pathak, so you also agree that there were two transformers operating. There was undetected consumption because of tapping through one. So when you went there, your assessing officer apportioned a portion of the consumption to one and the rest to two.
Why that has to be done, your lordship, is suppose now electricity is not a tangible item.
See, and
Feel it, how much is stolen.
you can only feel it.
You can feel it.
You want
yes.
it. Mm.
So if a meter is bypassed, your lordship, no way of determining what was the actual
Sorry.
connected load.
There is a way of determining by estimating the load.
Yes, and that, so what
Load
means is
capacity.
no, once it is bypassed, on that day, saying it gives a load, not know what
But they connected, you don't go by that. You go by the number of switches and
number of switches. So we have to assume that the bypass transformer has been used or abused to its maximum capacity. To hold a presumption.
this is what I asked you in the first day.
Yes.
That was a study made with
it was
regard to the transformer 1 supply
That instruction-
and the number 2 supply. You had not, the instruction says it was not made. So it's presumption.
the presumption.
It's apportionment.
It's a portion.
So apportionment cannot be in A. It has to also look into the consumption made by the first transformer.
Hey, submission.
It is also
That is
750.
not even required because the very formula which was applied, when the law mandates that you have to include both the transformers, there was no cause for making an apportionment. In fact, he should have included 938, the total capacity of
See,
both transformers.
5.8.4.4. What is the, Mr. For my understanding, what is the need for these provisions? No. The need for this provision is to compensate the distributor of electricity of a wrongful consumption, undetected wrongful consumption by a consumer. That's the underlying factor. Now, you are a state. Can you be compensated more than what you actually had lost? Because here it's double the tariff. It's 200.
200 is the estimated
Consumption, 2 into 2. So you are getting your loss plus a penalty, a compensation. So that will have to be done in a manner which is not prejudicial to you, at the same time, which is not taxing or not putting the person in excess of the penalty that he normally should face for a malpractice.
How these clauses are to be.
Mr. Pathar, these words convey the actual meaning to me. It's not even 2 years. So don't worry. Yes.
Now, for example, the word tariff is used. Okay, that for like a peculiar case such as the transformers.
Because these provisions are not envisaging a situation wherein there will be 2 or more.
2 or more transformers. Now, can it be a situation where a person benefit that's not stolen electricity?
Not benefit. He should be penalized to the extent he ought to be penalized, not more than that. Say for a theft, you don't pass a sentence of life imprisonment. But he has committed an offense. Offense is theft or it can be murder. The intensity would be different, but it's an offense.
My submission in that regard.
Give me.
They are interpreted. Effect of the legislative provisions relating to theft of electricity. So there are twofold objectives in that. One is to discourage people from indulging in.
Naturally.
Second, your lordship, to make good the loss.
Loss. Make good the loss and also a penalty upon the perpetrator of that.
When the provision under section 126 has been is the tariff. The tariff is calculated on the basis of the total connected load of the consumer.
Is tariff defined in the Act? No.
If your lordship,
It will given its normal meaning, trade meaning. Because that word is understood.
Differentiate your lordship and to give somebody just because there may have been a situation that maybe there is a transformer of a higher capacity, one single transformer.
See, that is why in 126, unauthorized use of electricity, transformer is not the factor, it's the meter. If you can come to B,
To a tampered meter.
So this is tampering of a meter. So if it is meter,
No, this lordship will see the other ones also.
well, okay, unauthorized means usage of electricity.
This is on the two, your lordship, B2.
By means of not authorized by the concerned person, authorized.
Authority or license. Not
Okay, fine.
probably
Let
the
us
meter may not have been tampered, but they have hooked the transformer directly to the electricity mains.
It is.
It would fall under
There
two.
there are 2 meters. There are 2 transformers.
I know that. The first meter, let's forget the transformer. It's a meter which would be bypassed or which would be tampered or whatever it is. Bypassing is also tampering.
Bypassing would perhaps not be an act of tampering per se, your lordship, because
It would come.
within the ambit of usage of electricity
Hmm.
by means which are not directly authorized by the electricity.
By a means not authorized by the concerned person or the authority or licensee. Okay. But it is again connected to a meter. So there are 2 meters.
1 meter.
There are 2 meters.
There is one meter is one, your lordship.
There cannot be. Otherwise,
Transformer-
the first one would also not have worked.
Lordship, meter is one because transformers are two total sanction load. There is only 1 meter, your lordship.
Then
If there is one decimal
come
number-
to your instructions.
Yes, your lordship. The meter number is given there.
You come, just read that has categorically stated that the consumer was involved in the threat of electricity by passing the energy meter number ASC 0823.
Yes, there is only 1 meter for the 2 transformers.
Then
Because if lordship will have the electricity, my understanding, I
no.
if one consumer,
There is 1 meter. Both these transformers come to that meter.
that is my understanding. Both
Cannot
the transformers come to the
Cannot
CPC.
be. Cannot be.
There is no
It will not hold. That is why 2 meters are given.
I'm not aware of this technical
I
aspect.
found somewhere. Just a moment.
I'm not very sure about this aspect, your lordship.
Come to page 26.
I'm on that.
But your lordship will see material seized. This is not meter as such. Meter was not.
No, this is
Page 34. FIR.
32.
34.
34.
Type copy.
Yes, your lord.
Bypass of meter number so-and-so of DTR, so-and-so bearing consumer number so-and-so to DTR so-and-so capacity 750 kVA. Make corporation grips to the tune of load 638 kV by means of tapping overhead of HT main before CT and PT. So there are 2 meters.
1 meter, your lordship. Meter number is ASC 0823. Bypass meter. Third two is the transformer number. Your lord. The other numbers which are reflected in that are numbers. That is
Each transformer will have a meter. No, it's okay. We'll ask Mr. So your case is that it should have been 938, not 638. The respondent authorities have already taken it at a lower stage.
lower stage.
So the calculation that was there went up on appeal. Even after appeal,
Reduced on appeal.
went up on appeal.
Yes.
After the orders of the appeal, you have passed a modified order. Further reduce the thing by now bringing down the period. Earlier it was 12 months. Now you have brought it for the period of 9 months and non-season 22.
My submission would be that both, in fact, the first formula also which was used
That was also right.
was also the
Rules,
rules
it should have been more. So he is already at an advantage.
already in
That is your.
not have I'm not for this aspect whether
Fine. Yes.
Lord, the appellate authority at page 62, I have already shown your lordship. Page 62. Whether we can ignore the possibility of total bypass of authorized connection load 938 intermittently from 11 kVA network so-and-so substation or intermediate use load from other transformer. So on that ground, possibility, our prayer was rejected. Then your lordship will see page 57. Page 57. Seventh line from top. The authorized connected load of 938 kilowatt was provided from consumers 2 into 750 11.0 kVA substations through HT meter.
Oh, 1 meter is there.
Yes, so and so. But the vigilance team during inspection found that while transformer number 1 was receiving power through 11 kV metering unit, the transformer number 2 was connected directly bypassing 11 kV metering unit. So whatever one transformer, my lord, it was receiving correctly and it was connected. Only one transformer was taken out. And then they have said, my lord, that whatever is bill we have already paid, that will be adjusted. Now, how they are adjusting? After imposing penalty, they are adjusting whatever I have paid.
Where is that adjustment?
It is somewhere, my lord, I am not getting it. Even my learned friend is not getting it. It is there, my lord, that
So there was some consumption there.
yes, my lord.
The assessment officers reported maybe that. There was a bill somewhere.
That's it. My lord, the adjustment of amount, if you're not page 67, my lord, I had already clicked your lordship. They had calculated everything, and thereafter, my lord, the adjustment was made.
Less already billed unit.
Yes. Yes, my lord. This was 50% of 159, which I paid for filing the appeal. But I have also, my lord, it's somewhere I'm unable to point out now exactly where it is, but in a small note after that, I will write where it is.
So, Mr. Mishra, your submission would be that there being two transformers and 938 being distributed from these two transformers. Admittedly, you are not going into the question whether there was a theft or not.
Yes.
You are admitting to that there was a theft.
No, I'm not admitting.
But you're
Because I
not
don't know.
disputing. You don't know. You're not disputing that.
know.
We'll put it that you're not disputing.
I'm a consumer.
You're a consumer. And this was done by some manager in your organization. Be that as it. You say that it should be distributed proportionally.
Yes.
And then the amount should be determined. And whatever the formula is into 200, you are ready to pay that.
That I'll pay, but my lord, if they are already they are adjusting whatever I have paid, even the bills, but they are adjusting it only after putting all the formulas to determine, my lord, including the penalty.
So they'll have to redo that.
Yes.
They will have to redo that.
Yes.
Come to the exact figure loss that has occasion along with penalty. And thereafter, whatever money you have paid, either if it is in excess, they'll refund, or if it is, they'll continue adjusting that amount in your future bills.
Yes.
Or if it is lower, if there is something more, they'll pay. You will have to pay. That's all.
Look, just one thing I want to show this a lot before. If your lordship can kindly come to 135. 135. Theft of electricity. Whoever dishonestly. So whoever, whether he is consumer and theft and thief both, or a person who is not even consumer, but he my lord, steals the electricity, he is liable to be punished. This is for the criminal part of it. That whoever does this so as to abstract or consume electricity shall be punished with imprisonment for a term which may extend to 3 years. Now, if a lordship will come to pay section 154. 154. 154, my lord, lordship will come to 5. Special court shall determine the civil liability against the consumer or a person in terms of money of theft, which shall not be less than the amount equivalent to so-and-so. So liability is against the consumer or a person who has stolen the electricity. So whether consumer is involved or not, the civil liability will be of the consumer. An explanation makes it very clear. Explanation, your lordship will see just below 6.
For the purpose of the section, means loss of damage incurred by the so-and-so or the concerned person, as the case may be, due to commission of offence referred to in section 135 to 140 and section 150. So in any way, it's the consumer who will be.
So therefore, my agreeing or not agreeing, they have come, they have detected, I have not disputed. That your lordship has correctly said, I have not disputed.
I just made that to just understand your proposition.
Yes.
And Mr. Pathak, your case would be that we have already calculated at a lower rate in terms of 5A, that 54, that supply code.
Section 126 subsection 6.
6 and 5A44.
5.A44.
You will have to do it at 938 into page 6.2.11, 200.
Yes. That is the assessed number of units consumed by their category.
Into the period. And you have also come down in the, after the orders of the appellate authority, you have also come down and the period was reduced in terms of the direction, and you have already made the adjustment also.
Lord, one more thing, I got it. At page 63, if your lordship will kindly
of the paper book.
Paper book, where it is.
In the other
people kindly come to somewhere just below the middle, my lord, the assessment of total energy consumed.
The assessment of total energy consumed, yes.
Thus evaluated as per clause so and so for the first instance of malpractice be adjusted with the energy already billed and paid by the appellant to arrive at quantum of theft of electricity.
We are only concerned with this portion.
And we have paid.
This line perhaps cannot be read.
No, there is another, we file a review in any case, and there is a reiteration
Review
of
is
this.
there, last page.
Last page, page 73.
That is why I'm saying.
Page 73.
Otherwise, review is not permissible in this, because the order is final, the section says so.
But there is an order for that. You should have filed a writ petition against that.
What I am saying, your lordship, is this sentence otherwise also cannot be read in isolation. Parameters of exercise of power under 5.8.4.4 has been laid down by the authority in the preceding sentences. He has said that first you have to undertake an exercise to determine the consumption during the peak season, then during the off season, then the amount that you arrive at has to be deducted. With the deduction per se, I have no objection, your lordship. That has to be done. But the calculation has to be as per 930.
Where is your review petition? Is the
there. But then page 73
is the order?
71
Order start.
order starts, my lord. 10-2 expected. Oh, here, my lord, I have we have said perhaps that as per the agreement, if your lordship will see at page 24, the agreement. The agreement.
24.
Annexure A is the agreement at page 25. Contracted demand is 770.29. 65% to 105% of connected load as per original agreement executed and at so and so power factor. At page 72, our claim was the appellant claim will be 7th line from the bottom of the second. The appellant claimed that total connected load of each of the transformer was 9 kW. Therefore, he prayed that assessment should be made on 9 kW load. That was 938. So they say one transformer. So we said take only 50%. So this was, of course, rejected. For review, I will not do. But it was filed and it was rejected, and it was again reiterated to adjust, to make all the adjustments, whatever.
That they have adjusted that amount, whatever bill you have paid at page 67. For the same period, 77,76,713 kilowatt hours was deducted. And what is this less already paid assessment amount?
50% we paid before.
That is this 50%, 89.
Yes.
So 127, you're
50% is it? So this is the amount, 50%, 89, 45, 856.
Yes. Yes.
This is the amount paid for preferring the appeal.
And we paid 25 lakhs here when we filed this writ petition.
Yeah. Okay. That was paid directly to the company or
After this court's direction, we paid.
which is, okay.
Otherwise,
The connection was not restored.
they would have disconnected.
Okay.
And the last one, my lord, as I have said, if your lordship will kindly come to the assessment order at page 60. As per the direction of the appellate court, they have assessed 9 months, 4 months, plus 22 days, 13 months. Whereas under section 165,
12 months.
Exit
12 months. So there is 1 month in excess, 1 month, 22 days in excess. Off season is for 4 months.
Off-season.
And 8 months season.
8 months is the thing.
So it should be 8.
Allot April to October is the season. So in
9.
place of 9 months, it should be 8 months. And 22 days, they cannot, my lord, because if they take 4 months off season.
Off season. So 9 plus 4, it's already 13. So this 22 days also ought not to have come in.
It cannot exceed 126.5.
How the Electricity Act is to be.
Give me those judgments. The error is because of the observations of the appellate authority. 9, 22, 4. They have just copied that. I don't want to retain this. Can you give me these xeroxes of this relevant pages? Not the act, only the supply code. And the note.
Well, in fact, now since I don't have to give that clarification on adjustment, I have prepared the note. I can give it right now. I've prepared a small note. Give copy.
You also, whatever is there, judgments you want to show, rely.
My note is what I have argued before, Your Lordship.
So this note that Mr. Pathak has formed, now that you also have it, so we will take it that it is come on record.
But your lordship has said so.
I think in the last date I said so. But Mr. D.K. Mishra, learned counsel for the, learned senior counsel for the petitioner, assisted by Mr. Learned counsel appearing for the, assisted by so-and-so appearing for the petitioner. I also heard Mr. K.P. Pathak, learned standing counsel, APDCL. Hearing concluded. Registry to list this matter date delivery 18/9 to be 18/9/2025 for delivery of orders. So you can give it to me whenever this week or next week. You can leave it with her with the citations. Any case laws you want to rely upon? Nothing.
Deeply. All right.
Yeah, Lordship.
Who is appearing for the respondents? Mr. Chetia, you are appearing. Gulagat Municipal Board.
Municipal Board.
Who is appearing for the municipal board?
Name has been shown, my lord.
There is somebody name reflected.
Yes, name has been reflected, my lord.
A. Borua M. Alam. Who are they? A. Borua M. Alam. Can you get hold of them? Your case is that alternative land has not been.
In the allotment letter, there was.
Earlier allotment order that was there. We only want to see as to the basis of that. If there is a resolution of the town committee in that lines, fine, they'll have to provide for that. So that's what I want to know. That the Supreme Court there was some restriction by the Supreme Court with regard to the biometrics collected during. Now that restriction has been removed. Then how come she has been? She would be given the benefits subject to the basing on the Aadhaar enrollment identification EID number or any other permissible identification tags. Now she has been issued with an Aadhaar card.
Yes, now she has been.
You have issued, fine, very good. Mr. AHMR Chaudhary, learned counsel for the petitioner, submits that the petitioner desires not to press the matter any further. Accordingly, he prays that he be permitted to withdraw the present writ petition. Prayer is not objected to by the learned counsel for the respondent. Accordingly, therefore, in view of the above submission of the learned counsel for the petitioner, the present writ petition stands dismissed on withdrawal.
Lordship, kindly pass by for time being.
Hmm?
Another court.
I'm being. Okay, Yes, Mr.
My
Sigdar.
lord, here in this case, my lord, the petitioners are river eroded people and there was a recommendation for allotment. Subsequently, before finalizing their on the giving
You
the effect to
claim
the
that
recommendation,
you were river eroded and you came and occupied this land.
and there is a, my lord, land advisory committee has
Okay, fine, fine,
recommendation.
fine. For
But
my,
subsequently, my lord,
for my information, where were you before you had come here? From which village were you land eroded, river eroded? Where is that certificate?
that has not been.
Because if you are land
My lord,
eroded,
they were, my lord, now we are, our land, the particular land where we are residing, where there was, for consideration of the allotment by the land advisory committee, that land has been my lord, taken for and widening of the,
okay,
of the,
okay.
national
That
highway.
is, I have read it.
My lord,
I want to give you your claim is an alternative land.
my lord, no alternative.
Compensation, whatever it is.
My lord, they're claiming only
Zira,
that complete.
Zira. Now show me that you had a land. You were in possession of a land before you had occupied this. And what happened to that land? And where is that land
My lord,
situated?
that I have to obtain some.
So your
My lord.
petition should have disclosed that.
My lord, only point is that we are claiming.
I know. For claiming that, you will have to show that you had occupied this land
My lord,
because
matter may come up after 2 days, my lord. In fact, my lord, I mean, I was in trouble. I could not go through the record also, my lord.
if Mr. Sigdar is in trouble, this court will not come in. Otherwise, your petitioners are in trouble.
My lord. Next week, my lord.
But Mr. A.R. Sigdar, learned counsel for the petition, and also Mr. H. Sharma, learned additional senior government advocate, and Mr. A. Burwa. On behalf, appearing for respond number 1 and 2. Also, the hearing remains inconclusive. Registry to list this matter again on 10 তারিখে পারি? Nori. কোন তারিখে পারি? 16/9/2025 for further hearing. You will have to satisfy.
My lord.
Yes, Mr. Deka. Long time.
Yes, ma'am. This is Deepatta land, my lord.
Miyadi Patta.
Yes, my lord. By the register sale deed, my lord, I am possessing the land since.
Forest wants to take over your land. You went for a title suit.
Yes, my lord.
Title suit was decreed, appeal dismissed.
No, yes, appeal dismissed.
Appeal dismissed. And now they have occupied your land, dispossessed you.
Yeah,
Yes, who is appearing for the forest?
last time, my lord, they have to time, my lord.
Same land?
Same land, my lord.
These photographs are of your land taken over.
Some activities of the restoration. Cutting of the tree, my lord.
But this is covered by which forest? They claim?
My lord, the area is, my lord.
Jorasol Reserve Forest.
Colossal.
Jorasol Reserve Forest. And when did you buy this land?
My lord, in 1982, my lord.
1982.
82, my lord.
The declaration is of sanction that wildlife forest was notified in 1878.
But one is the first is in 1926, I think, my lord. That is whether it is applicable. This, but I don't know, my lord. But
what are the boundaries? Was that issue with regard to boundaries gone in with the trial court? No.
They have disputed, my lord. They have filed a WS, my lord. They have adduced evidence. We also adduce evidence. But
what is the final conclusion of the trial court with regard to
77, my lord.
It says Khiraz Mati, but detailed, where is that detailed page?
77, my lord.
No, that is a final thing.
Yes, my lord.
Discussion?
discussion, my lord. My lord, it start from 68, page 68, my lord. And issues are, my lord, issues are important, my lord.
Issues that I want to see.
Page 72. Whether the
4, issue number 4. 5. 4 and 5. Issue number 2.
5.
Can you get hold of junior? Ask your junior gets hold of somebody from Forest Department. We'll have it in the second. If there is 1 or 2 matters fixed, thereafter we'll have it. Whenever you're free, just come down, we'll have it.
Yes, okay.
Who is appearing for the government? Get hold of somebody. Railway. Yes. What is this? No adjournment. Do whatever, I'm not granting adjournment. I want your man here, your senior commercial officer. What is this being done? There is a categorical order from this court. Clear violation. I'm drawing up contempt against him. What are you doing? Poor man, he is suffering. No, 2 o'clock.
Lordship,
You have got it.
I may relieve him. I didn't want to barge in between his statements. We have already got the.
Oh, then you should have told me. Mr.
N. Gogoi appeared.
N. Gogoi, Learned Counsel for the petitioner, submits that during the pendency of the present proceeding, the portal license of
been
the
transferred.
brother-in-law of the petitioner has been transferred in his name. Accordingly, he prays that he be permitted. Accordingly, he prays that the petitioner desires not to press this matter any further. Full stop. Accordingly, the writ petition stands dismissed on withdrawal. Otherwise, you would have had it today. And these things, this court will not bear. Poor people cannot be put to trouble. And there is a categorical, clear-cut direction passed in 2022, 23. And if there is something like this, tell in the first instance, why are you wasting my energy? Huh? Oh.
I was really reluctant to barge into the energy which you were deposing, your lordship.
22. Can it be possible for timing, my lord?
Why?
Santanu Kumar Das, he will be appearing in this. case.
Okay, we'll wait for Santanu Kumar Das. Who is appearing for the respondents? You are appearing, madam. Why this information is not being transferred? Who are you? Commission. Who is the person? Who is the person, Bilasipara? Who is to give you this information? Ah, you are there. Yes, why is he not giving?
Check, my lord.
Okay, who is the settlement officer? Is some foreigner? Indian? Your employee? Covered by you? What happened? 2 o'clock. 2 o'clock, you get call your, this matters pending from 2023, small issue, not giving, call him. Second half. Okay, today we are there, you give him, ask him why the information is not given, then tell me, I'll accommodate you for that. But get that instruction. On which date he is furnishing that, and that much only you get. Mr. Gogoi, it's only furnishing of information.
Otherwise, we have received instruction 2023, whether that part was complied.
That's right, just give him a call, wake up call, so that we can have the matter next week and dispose it off. Just give him a wake up.
Next week.
No. Otherwise, it will not work. Again, it will be adjourned. You give him a call. Get the information. I don't want these files to come back. All right, idea.
I have written state. Not want to pursue this.
Ah, very rightly so. Mr. S.K. Roy, learned counsel for the petitioner, on instruction submits that the petitioner desires not to press the matter any further. Full stop. He prays that the matter be permitted to be withdrawn. Full stop. Prayer is not objected to by Mr. B. Goswami, learned additional senior government, additional advocate general appearing for the state respondents. Full stop. In view of the above submission made by Mr. S.K. Roy, learned counsel for the petitioner, the present writ petition stands dismissed on withdrawal. Full stop. The interim directions passed by this court-wide order dated 21/7/2023 stands vacated. The respondents are at liberty to take further course of action towards demolishing the structure of the petitioner. Huh? Already done. Demolished.
There is a other case, my lord. I have contesting that case.
Okay, fine. Yes, Mr. Bro.
But I'm sorry, Milord, mentioning this matter.
No, no problem.
And 51, Milord, it has been fixed today at
True,
2 o'clock. Well, I have today, just now I have been engaged in this case. I pray tomorrow at 2 o'clock if you're not convenient.
Okay. I'll hear you tomorrow at 2 o'clock. There is no issue. We have asked for certain instructions. Let that be placed on record. Ms. Goel's, we are just on Madam Goel's locus in the matter.
Yes, Milord, I get to know about that. Regarding
You
the
come, you as the president, you come, we are always here to hear.
Now the question whether I can be implemented as a writ petition or
No,
not.
you cannot be. We will not permit that. You can file a fresh writ petition, come over, we'll consider. But I just want to know how the Panchayat had allowed somebody to operate without 105 being followed.
My lord,
that's the only instruction.
That is the only issue that has to be addressed to your lordship, my lord. Only things, my lord, yes, 105 definitely will not come, and there we have a newly formed, my lord, because the writ petition has been filed in the month of June, and we took this on July or on last.
So who gave the permission? The earlier body.
Earlier body.
Oh. Madam is in more difficulty now. Anyway, just that instruction we'll take on record. We'll hear you tomorrow at 2 p.m.
Oblige, my lord.
Yes, Mr. Chaudhary.
Yeah,
Yes, yes.
feeling well, my lord.
Which item?
26.
Mr. C. Chaudhary, learned counsel. Affidavit has not been filed.
Yeah, he will.
Okay. You can leave. I'll record your name. 26 of Monat Koidiva. Where is Mr. Dotto? Okay, maybe in the meeting. No. Mr. Standing Counsel. He is here. Yes, have you got the resolutions?
Yes, ma'am. One is 1/12/22. This, my lord, it was decided, my lord, they will the second may internal page 10. And resolution is there. Saying, my lord, only ex-collector Saha Alam, he was authorized to collect the revenue, my lord.
What is the date of that meeting? Where was the, Madam, where was that Shah Alam thing? Order? Empowering Shah Alam to collect the tax? 37. 13-3. Where is your 13-3 meeting? 13-4?
13-4. This is the resolution, madam.
No, this is 21-12-2022.
But there was another, my lord.
This is
10-4-23.
here it is only pertaining to Shah Alam. No other.
No other.
Yes, madam. If we come to your resolution,
My lord.
which is there, it says that 13-4 resolution, this was done. But 13-4 is only with regard to Shah Alam.
That means there must be a resolution prior to 13-4-20.
Then your this order 24-23 is wrong. It only refers to 13-4-23. Resolution number 2. And what is the second one? Second resolution?
That was earlier one, my lord.
21-12.
By that, my lord, the decided to establish.
Aji khabar Anchalik Panchayat under. And one thing, what was contemplated was a weekly market. Does it say it's a Pasukhat? No.
The
Is it both Pasukhat and সংগ্ৰহভাৱে জলেশ্বৰ আঞ্চলিক পঞ্চায়তৰ কৰ আদায়কাৰী শ্ৰীযুত খা আলমক ৰাজহুৱা সংগ্ৰহ কৰি জলেশ্বৰ আঞ্চলিক পঞ্চায়ত. Where is the one which was setting up the weekly market?
This is the NOC. This is of that.
Okay. There is a request made by Mr. Bora, Senior Counsel, for having the matter tomorrow, 2 o'clock. So we'll have it at 2 o'clock tomorrow. I think he's appearing for the newly implemented, that applicant, President. Also.
Hot copy I'll send.
As prayed for by the Learned Council for the party, registered to list this matter again on 28, 28/8/2025 at 2 p.m.
Yeah, after.
No, he wants it tomorrow. She's having some.
I have personal.
We have committed in the morning that it will be taken up tomorrow. Huh? He is appearing for the present town panchayat president.
In the meantime, my lord, at 18 June 20.
The interim order will continue till tomorrow. That is 28/8/2025.
I'm grateful.
Everything, because implementing and everything will come moment we are satisfied with the locus, the power under which madam is operating. If we are satisfied that that is through a bona fide power has been conferred upon her, then the matter, your thing, everything will come. But if we find that there is nothing, then the panchayat cannot go ahead with the matter. That much only.
Lordship, only
Let us see if we can bring in another 105(1) also. Let's see.
2 PM.
2 PM.
I'm
Give her a copy.
Yes, yes.
Yeah.
Timing to.
Yes, Mr. Gogoi.
There in the note.
No, why the others were taken forward and not cancelled? Because your decision is over all pervasive, that everything should go.
That is the tariff for the.
So why that was not complied in toto? When the chief executive says that everything will go, everything will go. How the power is there for the subordinates to take a different view? You give them, we will close the matter, but otherwise we.
But whatever said, we have taken. Monday, Lordship, may take up.
Why? How do you make that? How did you make that selection? No, there has to be something, some basis. Because he also had a select list ready. The others also had a select list ready. So if the same problem was there in all.
Going by my lord, that note, my lord, yes. The vision was not there, my lord.
Or you will have to accommodate them because they are the only people before us. That's the end of the matter. We'll make it clear. We'll make it clear.
Not come because on the same day, 2 select list was
Were published. Mr. B. Gogoi, Learned, Additional Senior Government, Additional Advocate General, appearing for the state respondent, submits that the instructions has been received by him, and he submits and prays that he be granted time till 8/9/2025 to file an affidavit in the matter. Also, prayer accepted, registry to list this matter again on 9/9/2025 for further hearing.
as part of Lordship.
For further hearing.
Lordship.
Heard Mr. S.K. Ghosh, Learned Counsel for the petitioner. Also heard Mr. S. Who is appearing for the urban development? Mr. Chetia. Also heard Mr. M. Chetia, Learned Government Advocate, appearing for the respondent number 1, and Mr. S. Dr. Learned Senior Counsel, assisted by Ms. K. Bora, Learned Counsel, representing the respondent number 2 and 3. Mr. M.U. Mahmood, Learned Counsel, appears for the respondent number 4. Also, the petitioner in the present proceeding has sought for a direction upon the respondent authorities for carrying out of a reassessment of his newly constructed building, on the ground that the same was so constructed basing on the permission granted for the same by the Silchar Municipal Development, Municipal Board, Municipal Corporation. The petitioner has further prayed for a direction upon the respondent number 2, that is the Silchar Municipal Board, to split up the holding number 571 of ward number 25 by issuing a new holding number over the newly constructed building. The petitioner has in this connection also presented a challenge to an order dated 4/3/2023, wherein the prayer for the of the petitioner for splitting of the holding number came to be rejected. Also, as projected in the petition, the respondent number 4 herein had instituted a title suit being title suit number 39/2013 before the Court of the Learned Municipal Kachar at Silchar against the petitioner, for declaration of right title and possession of an undivided 1/4 share of land of DAG number 3271 of RS Patta number 411, situated at Pargana Barakpar, Mauza, Silchar. The further challenge in the said suit is to a gift deed numbers 778 and 1553 dated 1513 dated 24/7/2002 and 26/4/2005. Also, it is full stop. The petitioner has further projected that the injunction petition as filed in the matter, along with title suit number 39 of 2013 was rejected by the Learned Trial Court wide order dated 22/8/2013. Also, the appeal as filed against the said order also having been rejected, a civil revision petition came to be, civil revision petition being CRP number 302/2014 came to be instituted before this court. Also, this court wide order dated 9/2/2015, while being pleased to dismiss the revision petition, had observed that if the defendants, that is the petitioners herein, make any construction alteration of the suit line, that would be so made at its risk and cost. Also, thereafter, the petitioner had sought for permission to construct the building over the plot of land, the same being not granted. What was the order in the writ petition?
Same was granted.
And the same being granted, came to be challenged by the respondent number 4 herein by way of instituting WPC number 8774/2018. Also, this court wide order dated 20/12/2018 passed in WPC number 8774/2018 had stayed the effect of the permission so granted to the petitioner herein. Full stop. The petitioner herein thereafter filed an application, interlocutory application being IA bracket civil number 2061/2019. Full stop. The said interlocutory application was taken up for consideration. Proceeded to interfere with the permission so granted to the petitioner wide communication dated 5/12/2018 with an observation requiring the parties to approach the Learned Civil Court for an expeditious disposal of the pending civil suit. Thereafter, what happened?
Thereafter, construction completed.
You got a permission.
Permission.
Subsequently, they gave you a permission.
Construction completed. I applied for.
Thereafter, it is projected that the petitioner on receipt of approval to the plan so submitted, constructed a building over the disputed plot of land Also, on completion of the construction of the said building, that is your permission. This is your application.
Application.
Submitted an application in the prescribed format for assessment oblique mutation of his name over the title of holding oblique portion of the holding submitted an application for reassessment and also for splitting of the holding number of the building in question. Also, the said application was considered, not being considered, comma, the petitioner instituted WPC, petition being WPC number 5876/2021 before this court. This court, upon noticing the issues arising in the proceeding, was pleased while order dated 31/8/2022 to dispose of the said petition by requiring the Silchar Municipal Board authorities to consider the application submitted by the petitioner, comma, herein, comma, and to dispose of the same by way of a reasoned order, comma, after also taking into consideration all such objections that may be raised by the respondent number 4 herein, comma. Also, in pursuance to the directions passed by this court, while the order dated 31/8, while the said order dated 31/8/2022, the Executive Officer, Silchar Municipal Board, while order dated 4/3/2023, proceeded to consider the application as submitted in the matter by the petitioner, and on such consideration proceeded to reject the said prayer on the ground that a civil suit between the parties is pending before the learned Munsif number 2 Kachar for final disposal, and accordingly it was held that the holding in the name of the petitioner herein be kept reserved until disposal of the aforesaid civil suit before the trial court, pending before the trial court. Full stop. Being aggrieved, the petitioner has instituted the present proceedings. Also, Mr. S.K. Ghosh has reiterated the contentions raised, reiterated the facts as noticed herein above, and has submitted that there being already a direction from this court passed wide order dated 9/2/2015 in CRP number 302/2014 that the construction of alteration of the suit of the suit land, including the construction therein, would be so made at his risk and cost, and accordingly he submits that the grant of the prayer made by the petitioner for a reassessment of the building and also for splitting the holding number would in no way cause prejudice either to the authorities of the Silchar Municipal Board and or to the respondent number 4 hearing. Accordingly, he submits that this court would be pleased to direct the respondent authorities to do the needful in the matter, and also has submitted that the order dated 4/3/2023 would mandate an interference from this court. Mr. M.U. Mahmood, learned counsel for the petitioner, at the outset has submitted that the very construction done by the petitioner, being subject to the outcome of the trial of the title of the civil suit, that in a civil proceeding being subject to outcome of title suit number 39/2013, comma, no further benefit with the petitioner is not entitled to have his name mutated against the said building and or to be issued with a fresh holding number upon reassessment of the building in question. Mr. Mahmood submits that any action in this direction would be mandated to be so taken after the title suit number 39/2013 is finally disposed of by the learned trial court. Mr. Mahmood has further submitted that the very
Gift.
means
Yes,
that
21.
the very basis for the petitioner to claim title over the plot in land being in challenge in the proceedings of title suit number 39/2013, comma, the petitioner would not be entitled to have the holding number with regard to the building constructed by him, would not be entitled to have the holding number issued in his name for the building so constructed by him before conclusion of the proceedings in the death title suit. Anything more?
Observations of this court may not be affected.
Full stop. Mr. Mahmood has further submitted that right. So in the above premises, Mr. Mahmood submits that the present writ petition would mandate a dismissal. Also, I've heard the learned counsel for the parties and also peruse the materials available on record. It is seen that a dispute with regard to the right title and interest over the plot of land covered by Tag number 3271 of RS Patta number 411, Parangana Barakpar, Mauza Silchar is a pending consideration before the learned trial court in the proceedings of title suit number 39/2013, instituted by the respondent number 4 herein. Also, the injunction prayer for injunction as made in the said title suit having been rejected, the matter had reached this court in the form by way of institution of a civil revision petition being CRP number 302/2014, by the respondent number 4 hearing. This court, while dismissing the said this court, while order dated 9/2/2015, while dismissing the said revision petition, had made the following observation. Page 16, A to A. A perusal of the said observations would bring to the forefront, Saptana, that this court had provided that if the petitioner's hearing continued with the construction / alteration of the suit land, the same would be at his risk and cost. The said order continues to hold the field till date. Also, in that view of the matter, the petitioner having constructed the building in question, no vested right accrues to him in this connection, inasmuch as the very construction so made would be subject to the directions that would now be passed by the trial court in the proceedings of in title suit number 39/2013. Also, accordingly, the grant of the prayer of the petitioner for reassessment of the building, newly constructed building, and for issuance of holding number in the manner as prayed for, would also not in any manner cause prejudice to the interest of the respondent number 4 and of the Silchar Municipal Authority. Further, in view of the facts as noticed herein above, the reassessment of the building being carried out and fresh holding number being allotted to the petitioner, no right would accrue in this connection to the petitioner, inasmuch as the same would also be subject to the outcome of the pending title suit between the parties, that is title suit number 39/2013. Also, 39/2013. So, in view of the above position, this court is of the considered view that the order dated 4/3/2023 issued by the Executive Officer, Silchar Municipal Board, having been so issued without appreciating the observations made by this court while order dated 9/2/2015 in CRP number 302/2014 would mandate an interference, and accordingly the same is set aside. So the respondents number 2 and 3 are now directed to reconsider the application dated. Page 26.
24.
24. Dated
9/4/2021.
application dated 9/4/2024.
21.
Submitted by the petitioner for splitting of the holding number as well as for reassessment of the building be now considered and a reasoned order passed thereon in light of the observations made herein above in the present order. So, it is provided that in the event the petitioner's prayers are so allowed by the Silchar Municipal Board, the same would not result in any right accruing to the petitioner, inasmuch as the very construction of the building and his claim for title over the said plot wherein such building has been constructed would subject to the outcome of the proceedings in title suit number 39/2013. So, in the event the respondent number 2 and 3 are directed to reconsider the said application of the petitioner and to pass a fresh order thereon within a period of 1 month from the date of receipt of a certified copy of this order. So, with the above observations and directions, the present writ petition stands disposed of.
Only
Yes.
showing our presence.
We have said SK Doctor presence. Mr. line after before Mamuda got Rikiba. Mr. SK Doctor as Doctor Learned Senior Counsel appearing for the respond number 2 and 3 submits that the Silchar Municipal Corporation would act in the matter strictly in accordance with the directions passed by this court in the earlier round of litigations between the petitioner and the respond number 4. "45 days, within 45 days. When Mr. Dotto says something, we can't say no. So, Mr. Mahmood, your rights have been protected.
We are satisfied.
An advocate should never be satisfied. Yes. Who is appearing for the municipal board? You appear. Yes, madam. Why this vacation has been ordered without providing for alternative land? Oh, Golaghat Municipal Board instructions have not come. Who is the authority to give you instructions? You are led by whom in this matter? K. Borua. Ask Mr. Borua to contact this body and get your instructions. We'll take it up after half an hour. 3 o'clock, I'm calling this matter. Just the instruction. Why the alternative plot of land was not given. There may be something. Just let me know. 3 o'clock.
20.
Yes.
We inform, but we're
Forest.
interim earlier, pass earlier, maybe continue.
Heard Mr. P.S. Dekar, Learned Senior Counsel, appearing for the petitioner. None has appeared for the respondents. So, for the ends of justice, the registry to list this matter again after 3 weeks on a date to be fixed by 3 weeks. Also, interim order passed earlier to continue till the next date of listing.
Good.
22.
Yes, ma'am.
Sometime, day after tomorrow. On the prayer of Miss M. Chetia, the matter stands adjourned. Learning Government Advocate, huh? Matter stands adjourned today. For registered to list this matter again on.
Can I
Not right?
4th, my lord, if possible.
17. 17/9. 17/9. On the next date of listing, Mr. Chetia shall apprise this court as to why the information sought by the petitioner under the provisions of the RTI Act, Right to Information Act 2005, has not been furnished to him.
Of information has been.
That you tell me, how will we know?
Whole information I will go.
Hmm. Here the matter is already referred to the what more is left? Who is appearing? We'll wait for some time. Maybe because of the meeting today, there is some delay. We'll wait for some time. 3 o'clock we'll take it.
May I please, your lordship?
Hmm.
Lordship, the mutation was cancelled, my lord. The pattadars and our mutation was cancelled on the ground that there is a partition suit is pending before the civil court, and that is the only ground our mutation is cancelled after granting it by following due procedure, my lord. Now, my lord, the question is whether the revenue authority who has effected the mutation after following due procedure.
Is there any direction from the
Yes.
from the civil suit in the trial court? There is any direction?
No, my lord, there is no direction, and that suit is purely a partition.
Give me 2
suit, my lord.
minutes. I'm seeing. Yes, what is the civil suit all about? Title suit all about?
My lord, civil suit is in respect of a total land measuring 18 bighas, my lord, and the
16 bigha 4 katha.
16 bigha 4 katha, sorry, my lord, and the present land in
It is within that 16
Yes,
bigha
lordship.
2 katha. That case is for partition.
Partition, my lord.
Partition.
The entire land.
For the entire land.
14 big,
Including this 2 bigha 4. So without that partition being occasion, how could they mutated your name there?
already our names were muted.
I know that your names have been mutated, but the plot of land that is not identified. It will be identified by the civil court only. Till that time, it will be a Esmali patta. One patta.
No, there are separate patta, my lord.
Separate patta.
Separate patta, my lord.
Okay.
Under this particular patta,
Is-
there is only 2 bigha 11 lesha land, my lord. 2 bigha 4 katha
If
11.
there is a patta already and that patta is not involved.
Let them file an reply to this affidavit, Lord.
Yes, fine.
I'll reply, my lord.
Where have you taken this plea?
Reply is not with us, Lord. That partition, that title suit regarding that partition is entire plot of land of
Yes.
that 16 bigha. This is the part of that 16 bigha.
Yes, my lord. That is so.
Without Judging the same by the learned trial court.
How did you come into possession of this land? You bought it from somebody.
All pattadars are in possession of that particular land, my lord. We are amicably staying in that land, my lord. Amicably, we are holding.
After the partition, he may not that part also, lordship.
Where is the Chita mutation? Here you have.
Chita mutation, lordship will find page 30, page 30, my lord. Copy, and the vernacular page 32.
Initially, it was done as because that was not within our knowledge, the title suit was pending. Our knowledge, lordship,
It was cancelled, but was a notice given to him before this cancellation?
challenging that he should approach the revenue board, lordship. The High Court is not the appropriate forum, lordship.
No notice, my lord. Suddenly it was cancelled with a note.
Where is that
That
note?
note, your lordship will find page 37, my lord. Right below, right. Note of Mandal.
You have inherited this plot of land
Yes, lordship.
from?
From Joshim Sheikh. He is the son of Ghero Sheikh, my lord. They are my grandfathers. The original owner was one Nek Mahmud, my lord, and all are the descendants of Nek Mahmud.
Had there been no title suit pending, lordship, then lordship, the matter would have been different because of.
My father name is there in the Chitha copy, my lord.
No, but it is a joint.
Yes, my lord. Joint.
Now, if there is a patta given to a particular plot of land, that means it is identified. If it is one patta, then I can understand.
Plot of land, that's 16 bighas. The partition.
The 16 bigha is not covered by.
It is a part of that.
No, there may be different, but patta is, there is a patta number here, 379. Bhag number 31, 2 bigha, 4 katha, 11 lesa. That is between these parties. And who has filed the suit?
Suit filed by the petitioner number 1, my lord. For partition.
Okay.
I have annexed the plaint, my lord. Copy.
Where is the plaint?
Page number 16 onward.
So Mokbul is P1.
Yes, lord.
And who are the parties?
And other petitioners are the brothers of Mokbul, my lord.
Just a moment.
Patta, lordship.
No, just a moment.
Asmal, yes.
Munjil is not a party here.
Yes, pro forma defendant, my lord. Page number 20.
Munjil, Ayub and Mohammed are pro forma defendants.
Pro forma defendants, my lord.
Yes.
Paragraph
After this, how can you? Because the very share is not yet
Yes, Lord.
determined.
From paragraph 5 onwards.
This will take care whatever happens. So why should we interfere with that? You have not disclosed that to the authorities
mutation.
at the time of mutation.
In fact, all
That
the
is your
stakeholders-
statement in the reply now. That is your statement in the reply. You have not taken that plea before the in the writ petition. Hmm. What is the procedure for cancellation of mutation? Mr. Bosho,
Notification.
some assistance is required. It's a family property of a grandfather. Then they are saying there is two patta, but different dog numbers. Now, these petitioners herein belong to one strip of that. So there are two katha something, 2 bigha something land. 2 bigha, na?
2 biha.
2 bigha out of that total 18 bighas is claimed by them, and accordingly they submitted, his father expired, so they submitted an application for mutation of their name. Prior to that, the petition number 1 had gone up and filed a partition suit. That is pending against all the heirs of the original one. Now this application for chitta mutation was done, and his name was incorporated in place of his predecessor. However, after the authorities came to know about the partition suit being pending, they have cancelled the mutation made on the ground that the civil suit is pending for partition. Now, what is the position of law in this connection?
Basically, against the mutation order, he is coming. Against that mutation order, he has to approach the
Cancellation of mutation. Assam Board of Revenue. There is an appeal provided for. Okay. That's
against that he can come
here. And what is the process for cancellation of a mutation? Already granted?
Of course, all the parties should be heard.
There has to be a hearing. Even if it is
By-
wrongly
by giving
mutated,
notice, ma'am.
there has to be a notice here. Without notice, that cannot be done. So if that is a violation at the very first stage, can't this court come in and interfere and remand back the matter? We can do that.
Remand back, yes.
By
Not heard, Lordship, in that case, writ lies.
writ lies. And you have also not said that he was heard. No statement in the affidavit that you were heard. So
And
on
Lordship,
that
I
count, we can send it back, huh?
I have filed one application also, my lord.
Huh.
That application, based on that application, was registered as miscase number 2722, page number 42, my lord. And that miscase was also dropped with the same observation, my lord. Page 42 is the
Okay.
translated. copy.
Against that cancellation,
Against that
you had.
cancellation. Yes.
Yes, Mr. Soma. Yes, Ms. Budley, anything? Huh.
Yes, then he can approve that.
That is that our new.
For cancellation, there is,
Okay.
matter can be remanded back, Lordship. In that case, writ lies, Lord.
We'll have to interfere with this order of cancellation.
Matter may be
Remanded back, let them take a call after hearing him.
That may be reflected in the.
Kali dia, Kali. Kali no, Kukurbai dia. Pass the order on Friday.
Lordship. Obliged, Lordship.
Heard hearing complete, registered to list this matter on. No, heard till parties at length, hearing remains inconclusive, registered to list this matter again on Friday. That day I'll pass the order.
Fine.
What is your name?
MM Zaman, Lordship.
MM?
Taman, Lord.
Kaman.
Taman.
Zaman.
ZAMAN.
And you are appearing for Bodloy? Any private respondent here?
No, my lord. No private.
26.
Highly obliged.
Mr. Das, what are you waiting for? After this item, we'll call it.
Petition was issued to file affidavit by the.
Lordship, as because.
Oh, Mr. Chaudhary's matter.
Revenue and Disaster Management Department. Communications.
What do you want? Ms. N. Bodloy, learned counsel for the learned counsel appearing for the respondent number 1 and Mr. 1 and 2. 1, 2 and 3. Hey, 4 was it? 1, 2, 3, 4. And Mr. H. Sharma, learned additional senior government advocate appearing for the respondent number 5 and 6. Pray that they be granted for the 3 weeks time to file an affidavit on behalf of the respondents represented by them. Prayer accepted. Registry to list this matter again after 2 weeks, no 3 weeks, 3 weeks. 3 weeks on a date to be fixed by it. File your affidavits.
Lordship, as because certain, the letter written from the Deputy Revenue Authority, certain legal opinion, what can be done with that opinion? We are awaiting for.
That madam will give it today.
Yes.
And then you send back the file. You give the opinion today. $24. 37 to
37, 37.
Only my difficulty is my lord. In 36, my lord, the MK Chaudhary is appearing, my lord.
Huh?
MK Chaudhary, my lord.
Okay.
He probably is busy in the meeting, my lord.
Okay. Have you filed the application for implementing?
That one actually I will have to take. Actually, we would not contact our client, my lord. Probably he is also not interested to pursue the matter because the period of the council will be expiring by the end of December, my lord. Yes. Then I will pray for time, my lord.
Mr. N.C. Das, learned senior counsel appearing for the petitioner, submits that the matter be taken up after 2 weeks, enabling him to take steps for implementing the Social Justice and Empowerment Department as a party respondent in the present civil. Also, prayer accepted. Registry to list this matter again. Mr. Das, after 3 weeks on a date to be fixed by it, in the meanwhile, the petitioner shall, in both the cases, you are the petitioner.
In 36, I am not there, my lord.
Petitioner in WPC number 117/2021 shall take appropriate steps for implementing the Social Justice and Empowerment Department as a party respondent in the present case, as well as file the affidavit after effecting service upon respondent number 4 and 23. Mr. N.C. Das, learned senior counsel appearing for the petitioner, petitioner in WPC number 117/2021. You are appearing for? You're not for the petitioner here. Mr. N. Das. M. Das, learned counsel for the respondent number 5 is present. Registry to list the above noted writ petitions after 2 weeks on a date to be fixed by it.
Lordship, I am appearing on behalf of Mr. C. Talukdar. He left the court due to medical emergency at his home.
A prayer is made on behalf of Mr. C. Talukdar for an adjournment in the matter. Prayer not being objected to by the respondents, the matter stands adjourned today. Also, registry to list this matter after 2 weeks on a date to be fixed by it. Yes. 12.
As per my instructions, they have a review. So that is not listed. They are challenging.
A prayer is made on behalf of Mr. C. Talukdar for an adjournment in the matter today on the ground that he is indisposed. Also, prayer accepted. A registry to list this matter again on 3/9/2025. Mr. A. Manaf, learned counsel for the respondent number 1 is present. If you have undertaken to comply, you will have to comply.
My lord, I'm seeking.
No,
Yeah, for Miss.
that is already filed. Last time also you took time. He was here the other day.
22nd, she was here.
And this was on 20th. This case had
No,
come up on
21st.
20th. You had made a prayer. We granted.
21st.
Sir? 20. So today, yes.
Kindly see that Farming Society Limited. Kindly mark this at page 4 in the cost item. Page 4. Singapore Cooperative Collective
Marketing Society.
Limited. And in paragraph 1 at page number 5, Lordship will kindly see first few lines, paragraph 1. Number 1 is a cooperative society. Under the cooperative society register number so and so. Dated 12/11/1960. Appointed by its president. Presidency is Sanjay Chauhan. And in the cost title, Lordship will kindly see Brojo Kishore Singh.
No, he is the secretary.
He is the secretary.
Sanjay Chauhan is the president.
That the presented by the president.
He is represented by Sanjay Chauhan only. And Broja Kumar Kishore Singha had come along. What would it be? Come to the meat of the matter.
Yes, Lordship will
Reported.
Okay, where is your affidavit? Where is your plea taken? Where is your plea taken? Then you wait for your turn. Yes.
Lordship will kindly page 16.
16.
My lord, only list of members of the purported cooperative society have been incorporated herein. In total, 58 numbers of persons.
It's a land deposit sort of a cooperative society. Okay. Okay. Then
Yes, now Lordship will kindly see. '25. On annual audit report and balance sheet for the year 2019-18 to 2021-22. Name of the society is Chandrapur Krishi Palm SS Limited. Lordship will mark this. Palm SS Limited.
just a moment, Mr. Where is the corresponding statement to this annexure in the writ petition? Okay, go ahead. Okay, okay, go ahead.
And Lordship will kindly say the petition is founded on an allotment letter that is dated in the year 1962 that Lordship will find at page 24. Thanks to your letters quoted above, Assam to temporarily being open of 300 bighas of land of the Golaghatia village grazing ground. It is their land in Hojai Moja in a compact for cultivation by Sri Chandra Singh and 25 others, and Sri Chandrakanta and 12 others. The remaining area of village grazing of these 39% should be reported in the year 1962. So Lordship will kindly is 30. Communication, my lord, from the sub-deputy collector to those persons. And my lord, 2 and 25 others.
Okay, got it.
Page 35.
Yes, 26-9.
Yes, my lord.
This is also for those people specifically. Then what?
Then Lord people kindly, my lord. Page 41. The type copy, my lord. At the limit of Golaghatia, there may be allowed to continue in Golaghatia VG. In this connection, a detailed report of Golaghatia VGR may be submitted immediately. Information to government at desires. Till 1965, my lord, it was allotments given to those persons by the government at that point of time was purely conditional. Then they have made a representation, my lord. Find at page 42, the type copy. That is in the year 1965. Settlement. 44, Lordship will kindly see the last paragraph. The society therefore prays that if thought necessary, report from and local officers may be called for an order for settlement as temporary basis be made permanent, giving a hearing and order passed to a stay order for eviction. At that point of time, there was a move by the.
Is this Chandra Singh and 25 others members of this cooperative society, or they have formed this cooperative society?
While affidavit will apply.
We have already rejected that prayer in the morning. We have granted you that prayer earlier.
What that may be.
The relief sought for that, Lordship will at page 13 of the only see, my lord. At page 14.
Mr. Pujari, a prayer is made on the ground that Madam Bormon is indisposed. So we are not putting her to trouble. We are having this matter next week or the week thereafter, and we'll finally dispose it off. A prayer is made on behalf of Ms. P. Bormon on the ground that she is indisposed, for an adjournment in the matter on the ground that she is indisposed. Full stop. Mr. R. Pujari, Learned Counsel for the respondents, by submitting that there is an urgency in the matter, had advanced his submissions in the matter. Full stop. However, the said submissions would be taken note of on the next date after hearing Ms. P. Bormon, Learned Counsel for the petition. Accordingly, registry to list this matter again on date 18/9/2025 for further hearing. No further adjournment.
maintainability, it is will persuade.
PW is supposed to file an affidavit, my lord.
This land of yours was acquired by way of direct purchase.
Yes, my lord.
Huh?
Right person.
The land also has a building.
Yes, my lord.
So when it was, that means it's an sale, basically. It's not acquisition, it's sale.
Sale and purchase, my lord, not acquisition, my lord. My lord, but there is no any such agreement, registered agreement for sale, my lord. And
How is this thing done? Direct sale purchase, how is it done? It will be a normal sale purchase only. It is not an acquisition.
My lord,
There has to be a sale deed also.
but although it stated as sale and purchase, my lord, kindly see at page 24. That is only the communication, my lord, where the authority has not even signed.
This is only a notice for hearing.
Yes, but
Then what happened?
no hearing has been done, my lord. And then, my lord, kindly see at page 27, that must has been provided, my lord. But my lord, now problem is that, my lord, that building actually not on the land, but it extends. My lord, what happened, my lord? The authority has taken 6 lessons of land. We have no problem upon that, my lord. But the land extent up to the beneath the building, one of building, my lord, that building has not been assessed and no any compensation for that building has been given. Therefore, my lord, by the order dated.
Because that building, the land wherein the building stands was not acquired.
No, my lord. Another Assam type house was there. Another 2 house, Assam type house were there, my lord. That were compensated, my lord.
Mr. Chaudhary, when can you file your affidavit? Mr. B. Chaudhary, Learned Standing Counsel, PWD, submits that the affidavit on behalf of the respondent represented by him would be filed on or before 5/9/2025. The registry to list this matter again on 17/9/2025. Yes, Mr. Roy. Mr. S.S. Roy, in terms of the queries raised by this court on the earlier dates of hearing, has on instruction submitted that the apostrophe be taught Assam State mental health rules apostrophe over quotation over are presently under process for grant of approval by the Ministry of Health and Family Welfare, bracketed Mental Health Division, bracket over, Government of India. He submits that the respondents, the respondents be granted further. 2 weeks time will do. Why? What procedure? What is that procedure?
Can throw some light in this. International regulations, international.
I'm not on that, ma'am. The rules have been prepared. It has to be approved by the Government of India. For approval of the Government of India, what it has to be sent to somewhere outside India. Then? Why? Let me know. Because this is not to be placed in the Parliament. Or is it required to be placed in the Parliament? Not the rules. Submits that the matter be taken up after 1 month. Also, prayer accepted, registered to list this matter again after the ensuing vacations. Ensuing puja vacations on a date to be fixed by it. You have 2 months. The next date when it comes, I want the rules. This is not a case of the petitioner. This is a case for all. No adversarial thing here.
Applies for setting the ball. 30.
Yes,
It has
Mr.
already been referred, my lord, to the Court of Competence.
34.
Oh, sorry.
Yeah, please, Lord.
Hmm.
In this case, my lord, raised objection to the candidature of the petitioner of the respondent number here in my lord. On 2 counts, my lord, at page number 34, as well as page number 34, saying that teenager girl was married, prohibited.
$34.
Teenager girl was married, prohibited, as per.
Just a moment. With due respect, and I would beg to state to inform you that I have submitted nomination so and so. But one candidate, Sajida Parveen, so and so has violated. It is mentioned that Shahid Ali has 4. Who is Shahid Ali?
Wife of Sajida, that means husband of Sajida Parveen. She is one of the candidates.
That Shahid Ali has.
Secondly, my lord, the educational qualification. And secondly, educational.
Where do I get it?
Then, is number 41, my lord. The type copy, and this is the. And now on 42, my lord, on page 42, at 43, my lord, a notice was issued. A notice was issued to Sajida Parveen, my lord, from Block Elementary Education, from the.
This is after the elections.
Before the election.
Now, if you have anything there, go file an election petition.
That is there, but my.
That is there means that is the only thing that is there.
My condition is this, that's because this notice was issued. No steps has been taken.
Forget it. Forget notice. That will not create any right. What is the procedure under the Panchayat Act? If you have to question, you will have to go before the election tribunal.
Before the election. took
Before the
place-
election, nothing has happened. The person is already elected, maybe wrong, but go before
notice
the.
to my prayer in this petition was that there's some steps has been taken by the authority that has not been,
No shortcut. No shortcut. Go contest. Panchayat action. Gracias. Where is that rules, Panchayat rules, election rules? Page?
Called disqualification by lot 1 on 11, my lord.
There is a Panchayat, Mr. Nath, there is a rules pertaining to this Panchayat elections. This is Panchayat elect, what Panchayat? This is Ancholik Gram, what is it? Gaon Panchayat.
'29, 129.
Page 129.
129B.
Yes. You have missed the bus. 60 days time is there. No election to any Panchayat shall be called in question except by an election petition presented within 60 days from the date of declaration of the election results to the tribunal constituted under section 127. Yes, Mr. Mishra.
As regards her selection to the election, my lord, election and his winning the election, my lord, I did not put any question there, my lord. My question was, when she submitted the documents.
Mr. Mishra, what you can do directly, you can do indirectly also.
That is true.
That
That is true.
you have missed everything.
No, my lord, my prayer was because that process was started prior to the election, my lord. So that is and it was all because of the declaration of the date for election, my lord. Because date was also fixed, my lord, on 13th April.
When was the election declared?
Election declared on 7/9.
7/9/25.
7/5, my lord.
7/5.
7/5/25.
So 5, 6, 7. You have missed the bus.
My submission is on paragraph annexus 11, my lord, page 43, because on 13th, my lord, the hearing was taken place and no result has been declared, my lord.
Can't help it, after the election results are declared, the provisions of the act would kick in.
So I am not disputing on that, but I found this question has not been addressed till today.
That is also gone because that was before the election. Page 43. Can't help it, Mr. Nath. There is no way out. Once the period is prescribed and it is gone. Section 14 in an election petition, I don't think so. Okay, you came immediately. Mr. Mishra, examine. If it is permissible that a delay condonation can be put there, I'll allow you. Heard Mr. M.K. Mishra, learned counsel for the petitioner. Also heard Mr. N. Das, learned counsel appearing for the state respondents. And Mr. R.A. Chaudhary, learned counsel appearing. H.R.A. Chaudhary. H. Ali, learned counsel appearing for the respondent number 5. Hearing remains inconclusive. Registry to list this matter again on. Short date. 11/11/2025 for further hearing. Mr. Examiner, I'll also look into it. But I think there is a. I'll have to examine.
It pleases your lordship, my lord. Pursuant to a auction process initiated by the respondent bank, my lord. This page 23. Lordship, this is the sale certificate. My lord, I invested rupees 29,50,000, my lord. And this land, my lord, 2 kotha 15 lesser was sold to me by the bank. So, my lord, there was in the meantime some litigation, and even finally the litigation pending in before the, my lord, learned court below at my lord Dibrugarh civil judge. That was also, that plain was also came to be rejected by this honorable court by judgment at page 49, my lord, 5/6/2024. As of now, there is no, my lord, case pending. However, the respondent authorities, my lord, the bank, my lord, page 25.
Took back the property.
My lord, yes, my lord, page 25, the last, hence the delivery of physical possession of property sold to you is temporarily held up till outcome the writ petition, and the writ petition also dismissed, my lord. This is of communication 2014.
When was the writ? Who had filed the writ petition?
Yes, my lord, this is the borrower, my lord, that page 27, Rajkumar Shah. And they were given some liberty. Thereafter, they have not approached them, my lord. Sir, DRT under section 17, my lord. And then again they have filed one IA application for granting some time, my lord, page 30. This and this time, my lord, this honorable court has, my lord, came heavily against the borrower. Page 32 is the relevant portion. Page 32 in the IA, the sought for time, we find no merit in the present application, primarily on 2 counts. Firstly, the applicant was not diligent enough to avail remedy under section 17 of the Services Act, despite sufficient time granted by the court to avail the remedy.
Any proceeding pending with regard to the.
Yes, this is my specific.
Half an hour? You want time only?
Be given.
From 2014, my lord, my payment, in spite of payment they received, my lord, and I could not use the land. This amount, my lord, pays.
Yes, Mr. Sharma, what is this?
Yes, sir. And we have also.
For what? For what? You have not been able to take the physical possession of the mortgage land.
How this?
Without 13(4), you have put it to auction.
Physical have taken a symbolic possession. Section 14 order. But what was happened thereafter has been filed by the borrower.
So now, moment you take physical possession, you will hand it over to him. Can I record that?
Yes.
Mr. M. Sharma, learned standing counsel, learned counsel appearing for the Central Bank of India, submits that the process for taking physical possession of the mortgaged property sold on auction to the petitioner is underway and would be completed soon. He submits that the jurisdictional district magistrate has already passed an order in this connection. Full stop. Mr. Sharma, on instructions, further submit that the property on being taken, a physical proposition of the property being taken, the same would be handed over to the petitioner herein in terms of the bid as made by him in pursuance to the notice, auction sale notice dated 8/4/2014, right?
My lord, as well as sale certificate, my lord.
As well as a sale certificate dated
27/9/2014, my lord.
27/9/2014. Full stop. Mr. Sharma, in view of the above position, submits that he be granted 4 weeks' time to apprise this court about the developments taking place in the matter. Full stop. Prayer accepted, registry to list this matter after 4 weeks on a date to be fixed by.
My lord, kindly fix a date, my lord. 2014, I am languishing, my lord. Lordship, this is my prayer, my lord.
Mr. Das, anything more is required. Mr. Sharma is very fair. Anything more is required?
My lord.
Give him
that's
some
all.
time, give him some breathing
Yes,
space.
yes, that's.
We'll bring it on affidavit also.
Yes.
On this.
Giving it to him, 2 days delay, fine, no problem.
Obliged.
Think that the executive magistrates are not intent to take it.
You file an application,
I'll file in WPC, yes, sir.
you file a WPC, we'll pass orders.
Yes, yes.
Obliged.
Filed an affidavit, my lord. After they filed their affidavit in opposition, the interim order, my lord, on the last occasion was vacated. By the rates, lordship, see my affidavit. I filed it, my lord.
Now your interim order is gone. We'll have to consider the writ petition only.
Yes, yes.
Give me a date, we'll consider.
Only thing is, my lord, because they have not acted thereafter.
No, yesterday was the date and that the technical.
What be that as it may, interim is gone. So there is no,
They are going ahead.
you're going ahead, no appeal against this order. Then Mr. Roy, hear the matter. After the vacations,
The purpose will not be there, but.
they have taken part. And very detailed, short order, but detailed one.
Yes, my lord,
But
considering.
your lordship, the main issue is that, my lord, they said that.
Mr. Roy, should we consider interim prayer now? It will be a final disposal. You make your submissions on a date to be fixed as agreed by you both. We'll hear you. Next 2 weeks, don't even think about it. Third day, Learned Council for the parties. So the Learned Council for the parties have submitted that the matter requires to be taken up for final consideration. Accordingly, as agreed to by the Learned Council for the parties, a registry to list this matter on 13/9. No. 22/9. Oh, 22/9, no. Last week is motion week.
Well, before that, my lord.
On 18/9/2020. 18.
Decision will be.
That is always there, Mr. Don't worry. Your interim order is gone now. What is there? Anything happens will be always there. Yes, madam.
Our instructions.
Just a moment, madam. No, we have been given an alternative land. When was the order given to you to vacate? Where is that?
12/5/20.
Page.
It starts from page 24, Lordship.
12/5. This is 29/5/2023. You have been given an alternative place near অস্থায়ী কৰিবলৈ দিয়া ঠাই সংগ্ৰহ পৰিৱেশ গোলাঘাট থানা আৰু ভেটেনাৰী হস্পিটেলৰ সংযোগী পথৰ কাষৰ সংযোগ স্থান আপোনাক ব্যৱসায় কৰিবৰ বাবে দিয়া হ'ল. You have been given an alternative plot. Go there. That's your instruction.
Where about it? If
You may not be aware. We are aware now.
Lordship,
We are aware.
Lordship, let them bring.
But then no record. Any interim order here. We are vacating that. You go. Alternative plot, they had given you alternative plot. If it is not suitable for you, leave it. Don't go.
Let the Lordship order, Lordship, record it in the order.
What?
Instruction on record, if Lordship may observe it then.
We'll do that. We'll do that. Madam, your name? Heard Mr.
NZ Chaudhary.
NZ Chaudhary, learned counsel for the petitioner. Also heard Miss M. Bhuya, learned counsel, appearing for the respondent number. Respondent number 5. Also, the grievance raised by the petitioner in the present proceeding is in relation to an action initiated by the Golaghat Municipal Board authorities requiring the petitioners to vacate the place allotted to them for setting up their business. The petitioners have prayed for setting aside the orders issued in this connection, all dated 12/5/2023. Well, madam? No, Their orders by which you have been asked to vacate is 12/5/2023. Also, Mr. As projected in the petition, the petitioners were allotted places by the Golaghat Municipal Board for doing business. Also, in this connection, the petitioners were issued with communications dated 23/2020, whereby the place so allotted to the petitioners in front of the public bus stand was identified. Also, the said communication dated 23/2022 also had a stipulation to the effect that in the event the municipal board decides to make permanent construction at the site place wherein the petitioners were permitted to set up their business, the petitioners are to vacate the place and run their business from a place or room which the municipal board will allot to them. Also, the municipal the Golaghat Municipal Board wide communication dated 12/5/2023 required the petitioners herein to vacate the place as allotted to them for running their business temporarily within 3 days. The said communication was so issued in pursuance to a meeting, a proposal, a resolution adopted in a general meeting held on 8/2/2023. Also, the petitioners being aggrieved by the fact that while being asked to vacate the place so allotted to them for running their business, they were not allotted an alternative plot of land / shop in terms of the allotment order initially issued to them. Also, today, when the matter was taken up for consideration, Ms. M. Bhuya, learned counsel for the petition, for the respondent number 5, Golaghat Municipal Board, has placed on record a communication dated 29/8/2023 issued to the petitioners herein by the President, Golaghat Municipal Board, wherein the alternative plot of land was identified for the petitioners to set up their business. Full stop. Also, the said communication being relevant is extracted herein below. Ekini copy koi dibo. 8-way. Also, a perusal of the communication dated 29/8/2023 would go to reveal that the municipal board authorities had provided for an alternative place to the petitioner to carry on their respective business. And the same is contended to have been done in terms of the stipulation made in the initial order of allotment issued to the petitioners on 23/2020. Also, it is to be noted that the petitioners had only raised a grievance before this court to the extent, a grievance in the present proceedings to the extent that while they were asked to vacate the place allotted to them, wide issuance of communication dated 12/5/2023, communications dated 12/5/2023, a alternative plot of land was not identified for them. Also, the alternative plot of land now having been identified, this court is of the considered view that no further adjudication would be called for in the present matter. Also, in the event the petitioners, you are still allowing them to go there? The learned counsel for the respondent number 5 has further submitted that the petitioners are at liberty still would be permitted to operate their business from the alternative plot of land as identified in the communication dated 29/5/2023. Full stop. In view of the above position, the petitioners are directed to carry out their respective business in the alternative plot of land as indicated in the communication dated 29/5/2023, 29/8/2023 day. So long, why was this not given to them? Why was this 23 order not given to them? Huh? Today? Okay. এইখিনি লিখিলা নহয়? Submit the answer. Last to lako, if I can any idea, it order sheet of Nukumaba, as agreed to by the Lana Council for the parties, registered to list this matter again tomorrow at 2, Friday, 29. Madam, ask your authorities why this was not, I'm disposing it of, why this was not communicated to them till today. 29th. 29, huh? In order to be khali in a type kori file or homediba hukurbare to did. No. Friday. Let me see why this was not. If I dispose, they have cancelled, you will be again in trouble. Why should you come back? We'll ensure that you get it there.
The Lordship is vacating the hearing, then sometime may be allowed to relocate.
Oh, we'll give you enough time. Interim order to continue till Friday. Khali tomorrow ikhini thakibo. Madam, you have your instructions. Give it to me. Right? We have a bench. I'll have to rise. Any date you require, anything you require, you can just have a talk with Madam. Which one?
Has already been referred to my lord.
That's what I'm saying. What is here? Nothing is here.
But despite my representation, there was not informed to the petitioner.
That is now there is an order. Not something survives here.
There's nothing, my lord.
Mr. P.J. Soikyal on a counsel for the petitioner submits that the collector, competent authority having already referred the issue to the principal civil court of original jurisdiction for adjudication of the Mr. P.J. Soikyal on a counsel for the submits that the matter having already been referred for adjudication by the principal civil court, the grievance raised by the petitioner in the present proceeding stands redressed. Accordingly, he submits that the issue would now be decided by the principal civil court to which the matter was referred by the competent authority, land acquisition.
It was referred 2023, my lord. 2 years already, my lord, gone by, my lord. So I may
Raised to list this matter again on Tuesday, in a side. Tuesday.
Please, your lordship, item
23
59, well, may please be shown in the cause list as the as counsel for.
39, raised to list this matter again after after 2 weeks, showing the name of Ms. M.S.S. Sharma, learned
Obliged, lordship.
counsel for the respondent,
For the petition.
for the petitioner.
And for the respondent in.
Hello, item 43, service is completed, my lord, but
Sir, I can't because I have a bench at 4 o'clock, so I'll have to rush. So any date you want, any urgency, any interim order is there, just tell her, we will extend it.
order is to be extended and copy is to be sent to the OC Onjuk Pani, only this must, my lord.
No, we'll have it. Kiman item number? Item?
43, my lord.
Huh?
43.
43, so. Yes, what do you want?
My lord, the service is completed, my lord. As per the office note dated 14/8/25, my lord. Interim may be continued and the order of interim may be, a copy of this order may be sent to Anjuk Pani police station, my lord, only for protection of the order, my lord. They are not obeying the order, that's why.
Registered to list this matter as agreed to by the as prayed for by the Lanark Council for the petitioner, registered to list this matter again on 5/9/2025 till the next date of listing. The interim order, the interim order shall continue till the next date of listing. We'll see on the next.
In item number 40, on the last date, I was allowed to implead a respondent, but I was not, an order was not passed specifically to amend the cost title. That may be allowed, so.
42, sir. Have you taken steps? Heard Mr. R. Singh, learned counsel for the petitioner. Mr. Singh submits that he be granted permission, he be granted 2 days time to file a amended cause title in the matter. It is submitted that the steps upon the respondent number 6 has already been taken. When did you take?
My lord, on the date itself, on 25/6.
Also, registry to oh, Mr. Hendig has accepted. Huh? Also, prayer accepted. Mr. The learned counsel for the petitioner shall file the amended cause title within 2 working days from today. Registry to thereafter list this matter after 2 weeks on a date to be fixed by it.
Right.
After 2 weeks, reflecting the name of SC, Standing Council Revenue for the respondents.